For delivery of order, item 1, bail application 12/27 of 25.
May it please your lordship.
The bail petition stands rejected.
Highly obliged, lordship.
Item 2, bail application 12/28 of 25.
Same here, bail application is rejected.
Prayer for adjournment, if any.
May it please your lordship.
Yes,
Therefore, listing BA lordship and more than 7 months in custody lordship, motion matter lordship, can it be 9 lordship?
9 is may not be possible. Yesterday also we have checked. 8 and 9 is almost full. Yes, when it can be.
Motion lordship.
No, motion to nowadays motion is the main.
And lordship, another
20 of 21.
20 or 21 will be too late for you.
so lordship automatically it will become whether and lordship another submission lordship and
Automatically means you want
normally lordship.
normal course. Okay.
Lordship, another submission, lordship, and the one AB lordship, yesterday, tomorrow is fixed matter, lordship, but 8 on list already been out, lordship. My matter is not listed, lordship, and the interim is not there, lordship.
Tomorrow?
Tomorrow, lordship. And tomorrow is
Yeah,
holiday.
made yesterday also 3-4 requests has been made for tomorrow's matters to be aided. We have rejected all these matters. It will come either 8-9 as per. Maybe supplement water, I don't know. Some matters may be there.
Lordship.
Because 8 is already is open bar and then 8 more matters have been fixed. And thereafter, if supply is there, then it's okay. But otherwise, we are not listing because yesterday also I rejected the prayer. Because tomorrow many matters were there, in fact.
Lordship, obliged.
Please, your lordship. Lordship, I beg to withdraw lordship item number 10.
Why?
Because there are receiving a stolen property charge sheet has been filed. Lordship, we will get there only. Lordship.
Okay. Do you have any instruction, Mr. Goswami, in regards to filing of the charge sheet?
Recently, it has been filed. Lordship.
Okay.
Tomorrow.
May 2.
Yes, sorry, yesterday.
Yesterday.
Lord.
Okay.
Yesterday, it has been filed.
Wait, I worried about it. Okay, it will be disposed on later.
Going for approach there. Much obliged.
May
Much-
it please, your lordship. Firstly, I beg to mention for listing on BA, on Friday. ma'am.
No, sorry, that's what I am saying. Friday, we are not possible. Thursday, Friday, almost full. Maybe by 13, 14, I don't know. Can be.
My lord, BA, my lord.
Huh?
BA.
Whatever, what to do. It's
Monday,
not
ma'am.
possible.
Then Monday. ma'am.
No, you can say Monday, we have to see. Monday is holiday otherwise. Many matters are there, what to do? We are insisting on dates and we are giving dates, huh?
20, 21 of 20.
20, 21, 22 at best. 20, 21, 22. We don't
Already
have.
numbered.
Pardon?
Already it is numbered, my lord.
Yes, numbered. What to do? Yes, it is numbered. 20 at best 20.
May it please, your lordship. Lordship, this matter I have mentioned earlier also. Your lordship was pleased to fix the date on 7th due to this holiday. So in
Oh,
that
that's
case,
same submission.
on Monday,
Monday is a holiday. I don't know, 13th may not be possible. That's what I am saying.
or 16th.
You may approach the registry, I think, in that case. Both those matters which 20.
Yes.
Okay, 20.
On the beg to mention for listing of a criminal petition also.
Mm.
Last listed in 2022 only also. So maybe next week on 16th.
16.
16th. right?
16, don't take it 15, 16, let it 14th. 14, 1-4.
14th.
Yes, 1-4.
May I please, the lordship? Lordship, I beg to mention for withdrawal of one bail application, lordship. Can it come day after tomorrow?
Thursday. Yes.
Much obliged.
Might please, your lordship. Lordship, item 7 may be taken up along with item number 22.
7 with 22.
22. Deeply.
Please, your lordship, which I beg to mention for listing of the BA, your lordship. Let twist the your lordship.
It will be
Okay.
listed either 20, 21 or 22. We don't have any space, in fact. That's what. At best 20 or 21. 20? 20? Okay.
Daily list item 3.
Yes,
Lordship, I beg to declare for time being senior will be a clear.
time being.
Yes.
Okay.
Item 4.
Hi, please, Your Lordship. Your Lordship, in this matter, we are supposed to file one additional affidavit with Your Lordship. So, to this time may be given, Your Lordship. The matter may be listed on 14th to 13th, Your Lordship.
13, 14. You're going to file an additional
Yes,
affidavit.
To bring some additional
Give us
documents.
space, Asaniki, 13, 14, 15. We don't have any space what to do. We are very sorry to say, but
Then Your Lordship kindly fix.
no, no, we don't have space. That's what we are asking her to see. 15th, 1 5. In 4, item number 4, na? At the request made by students, matter is adjourned. 15th, what we do? Enabling the petitioner to file the additional affidavit. Okay.
File.
Item 5.
Make pleasance. Lordship, allegation is there and the 2 person arrested along with a car and beef.
What I meant.
Lordship.
Beef.
Lordship, I am not there, Lordship. They were arrested and subsequently on the basis of their statement, I was arrested, Lordship. So, Lordship may kindly peruse FIR, Lordship. Page 14.
Yes.
May I read, Lordship? With so and so, I have the honor to report that today at 5 AM in charge of so and so received secret information from reliable source that 2 person carrying so and so by a silver colored swift Desire vehicle bearing so and so number from Purbo Polimari, West Bengal and proceeding towards Grahampur, district Kokrajhar, Assam. As per information, I along with IC so and so to conduct patrolling at the border areas of Grahampur and Purbo Polimari. During patrolling, we have found that the vehicle of so-and-so road. As per information, we conduct search of the vehicle and found 2 people illegally carrying approx so-and-so suspected to be beef in the vehicle. We apprehend 2 persons. The Shahalom and another Bakar Ali. We are not here. But after they were arrested, their court is before the court below and court below granted 2 days police custody. And then on the basis of their statement, I was arrested. Actually, I am no way involved in the case, but when I went to my father-in-law place, Lordship, because of his illness, so I was arrested from the house of my father-in-law. That too in West Bengal, Lordship. And this act doesn't also extend to West Bengal, Lordship.
You have annexed your forwarding? Forwarding of your?
The Cattle Preservation Act itself, right?
No, no, no. Forwarding.
Yes, page 19.
Page?
19.
Round number 4, Lordship, may peruse.
Yes, on the basis of the arrest.
So it is not only he stated to be habituated in admin of it.
Let the case will be confirmed.
Since when he are in custody?
It's in 19
Since
18 days
1904.
today, sir.
Today is 18 days. When can
May I
it
pray
confirm?
for a short date, Lordship?
We don't have short day.
From Kokrajhar district, my lord, we'll fix it on my 19th, my lord. 19 or 20.
19. 19 can be okay.
19.
19? Cool. 19.
Blood.
Item 6.
May I please, your Lordship? Yes. Well, the case registered under section my lord 20B and 20C also. From a train, my lord. The informant and his team recovered 2 bags, my lord, and found ganja. in a course number so and so. The present petitioner was the one of the passenger. And he denied, my lord, that he was not carrying the bag. And suspect, my lord, arrested him.
Hmm.
Already, my lord, today is 46 days behind the bar.
Yes, so you can,
Commercial quantity, man.
this has to come from where?
My lord, it is GRPS, my lord, Mongaigaon.
Bongaigaon,
23 May, man.
23.
23, 5.
23. Today is 40 days,
46 days.
46 days. Okay, 23, 5.
20.
Okay, we call it.
Obliged.
Item 8,
7 to ইহঁতক মাতিব নেকি 7 ৰ লগত 22 তেওঁ আছে নে ইয়াতে no no yes oh then 22 oh.
Lordship, this matter may be please taken up after some time.
Timing
Yes, Your Lordship. Okay.
item 9,
Well, not,
yes
this bail application was actually your lordship has rejected earlier occasion.
oh,
The
sir.
petitioner before your
Also.
lordship is behind the platform about 300 days now. 3 years.
3 years
Yes, madam.
It's
Trial
the
is,
Foxo
yes, yes, POXO trial is.
how many witnesses have been examined as per
Already 25 to 26 have been added.
25 to 26
Yes.
examined
Yes. There are 90, more than 90 witnesses. Are there.
oh why what is the kind of case this one is
So with regard to the minor girl who was found to be dead in hand condition. Later on, it was initially recorded, the UDA
the
case was
earlier
registered.
initially it was UD case registered.
Yes, then it was later on, my lord, the dead body was re-exhumed. Re-examination was done, postmortem was again done. And then on the second postmortem, it is, my lord, they found that there is some, my lord, discrepancy in the first postmortem and second postmortem.
Oh.
Accordingly, the 302 and my lord, POXO.
Is
all have
that
been-
it?
So that is the issue. All accused have been granted bail, my lord. The doctors were also accused there. The doctors have been granted bail.
But
The
doctor
doctors, yes, my lord, doctors who did the first postmortem. report,
postmortem
they were also accused, my lord. The magistrate who did the, my lord, the inquest,
Ah.
he has also been arraigned as, my lord, accused in this case.
acha acha
So the case trial is going on, my lord. I'm cooperating the trial. I have no issue. But the only thing is that, my lord, now, almost 3 years, my.
Yeah, obviously it is quite a reasonable period
yes,
we have
3
in
years.
custody.
So at this stage, my lord, probably in this case, my lord, the special PP Javed Ali Hassan will appear. My learned friend is appearing on
Yes,
her
Your
behalf.
Lordship. Appearing on his behalf, Mr. J. Hassan.
So notice has to be go.
Mr. J. Hassan, why on what strength he is appearing?
My lord, he is a special public prosecutor has been appointed in this case.
Oh, special public prosecutor.
Yes.
Acha, so what is this J?
J. A. Hassan.
J. A. Hassan. Acha.
His name may be shown, my lord.
Okay, we'll direct this one. Now see, once rejected, definitely we have to call for the case
Yes.
record
Yes,
along with the case diary. Heard Mr. J. Pine, the learned counsel for the petitioner, and also heard MS M.K. Brown appearing on behalf of Mr. J. A. Hassan, the special public prosecutor. Considering the submission made by learned counsel for the petitioner, let the case diary along with the CTB call for, okay? When it can be fixed, I don't know.
it is, the trial is going on. Scan copy may be necessary.
Yes,
Otherwise,
scan copy.
please scan
Scan copy. We are calling for the scan copy only. 23, 21, 405. 23rd of May.
Yes,
Oh, 20.
my lord, the respondent number probably.
Oh,
notice has
sorry,
to
we are
go
going to
respond.
reflect, the registry is accordingly directed to
No,
reflect the
it is-
name of Mr. J. A. Hassan, the learned, as a learned, the J. A. Hassan, the special public prosecutor. We are directing the registry to reflect the name. We are directing this, yes.
The notice has to be go through, my lord, via, my lord, the public prosecutor.
Respondents, how many respondents? are
One,
here?
my lord, only one.
Only one.
Respondent number 2, my lord. Respondent 1 is
To
the state.
judicial police station, to the office of the registry and the special public prosecutor.
Yes.
We are restricted to a special public prosecutor.
Yes.
Oh,
All right.
11,
Yes.
If the FIR is registered under section 21 of the banning of unregulated deposit scheme act 2019
Hmm.
and section 316 and 318 of BNS.
316 and 318 is also
318.
there. BNS.
Basically, the case is about the illegal deposit, that is the illegal trading.
Yes.
And along with the FIR, the informant has given a list of the middlemen who induce the investor to deposit in the unregulated scheme.
Hmm.
First, you will find the FIR is on the page number 9. But my
Hmm.
name is neither recorded in the FIR nor listed in the as a middleman. I am a simple depositor. I have deposited money, but I don't know why the police is now running after me to arrest only because on the ground that I have deposited in the unregulated scheme. I may be allowed to go through the FIR, Lordship.
Have you received any notice?
Police has visited my residence twice. But you will find that the two persons are named in the FIR. May I have the permission to read just one page? With due respect, one Muhammad Tahiruddin, along with several other unemployed youths from the Badarpur and outside, would like to bring to your kind attention a case of financial fraud committed against us. That said, 1.5 years ago, two individuals, namely Muhammad Shakir, aged about 28 years, son of Hafiz Muhammad Haranur Rasid, a resident of Bakarsal Post Office, so-and-so, PS so-and-so, district Sribhumi, and one Rajdeep Dev, age so-and-so, son of so-and-so, I'm not going to read the address, approached us, introducing themselves as a traders. They built a good rapport with us and gradually started showcasing their profit and claiming that if we invested money with them in the stock market / trading, they would provide us high return. Falling for their manipulation, we invested our hard-earned money. Some individuals even took bank loans to fund their investment. Initially, for a month, they provided return as promised. However, after some time, they started making excuses and delaying payments. Later, we discovered that they operated with a well-organized network involving both forward and backward groups, running a fraudulent investment scheme. Along with their associates, they collected substantial amount not just from us, but also from many others through intermediaries and brokers, falsely promised extraordinary high returns from stock market investment / trading, oblique trading. Through their conspiracy, they collectively looted crores of rupees, and when they failed to deliver the promised profit, they resorted to deception and misappropriation of the funds and attempted to escape. These individuals have been running multiple schemes to collect money. They had several middlemen, mediators, and intermediaries who manipulated people in the same way. The accused not only collected money directly, but also gained access to the demat accounts of multiple investors. Through this access, they misused the victims' linked bank accounts, chipponing of their funds and pretense of investments. Under the pretense of investments, and they also established an unauthorized training center where they lured people into investing under the pretense of providing courses only to defraud them later. The frauders, Mr. Muhammad Shakir and Rajdeep Dev, have even collected money through both cash and online transaction, directly and indirectly via their agents. A list of these mediators' agents is mentioned below for your kind reference. Lordship, the list is there also. There are altogether 13 agents or middlemen, but my name is not there. But unfortunately, what happened, Lordship, in fact, I am the victim of such unregulated scheme, and I have invested money from my account as well as my father's account also. But somehow police has got information that I have invested and I have managed my father to invest in the unregulated deposit scheme. So police is running after me. assuming that I am a middleman. Lordship, this deposit and deposit taker, investment is not a crime as per the section 21 of the Act. The section 21 of the Banning of Unregulated Deposit Scheme Act says that Article 21 says that punishment for contravention of section 3, any deposit taker who solicits deposit in contravention of the section 3 shall be punishable. So the deposit taker, not depositor. And who are the deposit taker? It is candidly defined in the section 2, subsection 5. Depositor means any person who makes a deposit under the Act. This is deposit, this is me. And the deposit taker means any individual or group of individuals, a proprietorship concern, a partnership firm, whether registered or not, a limited liability partnership registered under a limited liability partnership.
Anyway,
Act
you're saying that you are the depositor only.
Yes, I am the depositor only.
But police is searching for you.
Yes.
But
I
we
mean,
need the
we
case
cannot say anything against what is enrollment in this case.
But record says that my name is not there neither in the FIR nor in the middleman lordship. No.
That's what I'm saying during the course of investigation, there may be some reason maybe there.
May
Or
come
the
out-
CD will reveal everything. In fact, whether you are simply a depositor or maybe a victim also, or you are otherwise you are doing. Because
Lordship,
two
then
persons
still-
were arrested, behind them, you may be one. That is the question.
If that investigation, everything will reveal, obviously, if my account is connected to the traders, if I'm a middleman, then obviously some transaction between us and me. So say, let them proceed as per their own way. During course of investigation, if anything come out, then I shall be
Okay, we
prosecuted
call
as
for
per
the
the
case
law.
diary only at this stage.
Lordship,
Yes, when can it be called for?
I may be interim protection. No coercive action, Lordship. But the
Yes, when it can be called. for?
23-5.
Lordship, no coercive action till next date, Lordship.
We are calling for your case diary on 23/5. Sorry.
This is, Lordship, my humble submission is that, is there anything reveals a single
Then automatically your bail will be cancelled. That is obvious, but now we are not. We are
Lordship,
not.
till next date, no coercive action. If anything comes
23/5,
out,
CD is called for.
neither my name is recorded in the FIR nor as a middleman,
do?
Lordship. There is
Yes,
nothing against me, Lordship, as per the available in the records, so which I have placed. So no coercive action till next date, Lordship.
No, sorry. We are calling for the case diary only. Yes,
Item
next.
12,
The case may be taken after some time. Mr. HOD is legs in court number 6, madam. I think,
After
but
some time.
after some time, ma'am. He will be coming in. Obvious.
Time being kept out of matter, will you say?
for bail hearing, item 13,
In this case, my lord, nothing recovered from me, my lord. I was,
First tell us it is also from Shivbhumi.
and my lord, I was arrested from a hospital. And in fact, my lord, I got injury, my lord, due to the attack of some miscreants under the bridge, my lord. Because I have some revenge with some persons. And perhaps, my lord, the prime accused who has stated my name due to out of this, my lord, animosity, my lord. So I have been arrested. However, my lord, in the meanwhile, my the prime accused who has been granted by your lordship, my lord, I would like to place this.
Your, from your petition, anything recovered?
Nothing recovered. Nothing recovered.
How you sustain injury?
I sustained injury because it is a photograph is
Your-
there.
Fleeing away from the place or what?
I was admitted in hospital when I was going to my home at night, my lord. And some miscreant has
No,
attacked me.
some miscreants were attacked or police
No,
chased
no,
you?
madam, some miscreant had attacked, for which I got admission at hospital. Subsequently, after 1 or 2 days, police came and arrested from the hospital. This
So
is the
since
thing.
when you were in custody?
Since, my lord, since 10/11/2024.
It is not yet charge sheeted, well, case is charge sheeted.
Charge sheet. LCR is there, my lord. Record is also there.
Apart from these two ground, any other ground?
Any other ground, my lord, the prime accused from whom the recovery was made, he was granted bail by your lordship. But for a moment, kindly see page
So
33.
here also you taken this, the plea of non-furnishing,
I'm sorry.
non-furnishing of ground of arrest you have taken here.
Yes, I have taken, affidavit is fine.
Where is it? Your
Affidavit, page 92 to 98. I have taken
92.
92 to 98, my lord. 95, 96, 97, and 98. These are the, my lord, ground of arrests.
The petitioner's name is?
Okay. And page 95, arrest memo. Page 96, inspection memo. Page 97, my lord, notice under section 50 CRPC.
Yes, any other submission?
Mission, my lord. Kindly see page 33 for a moment. My condition is there. And I am almost dying at hospital, now at jail, my. Kindly see page 33, 34, and 35. What is my condition? And I was arrested from that situation. These are some dacoits attacked me, man.
You sustained basically fracture injury on your hand.
And hand and also my lord at hand and also at chest also. And leg also, my.
Yes.
And my another small submission, my lord. In record, my name is Fazlul Haq, FAZLUL. And another name is Faizul Haq, and in police entry it is Fazlul Haq, JLUL, for which I have, my lord, for clarified, I have filed this affidavit, my lord. Kindly see page 99 to 103. It is on record, my lord.
Police is issuing notice on Fazlul.
Police named this entity as Fazlul Haq, FAZLUL. However, in actual name, my lord, FAZLUL. And petition, my lord, it is written as Faizul Haq, FAIJUL. So, my lord, that can be treated as one and same person. Indicate I have filed an affidavit. J and I, my lord, this sometimes it is mismatched.
Otherwise, your name is Faizul. Fazlul.
ZLUL originally. I have my.
And you are forwarded as Faizul.
Huh?
You are forwarded as Faizul.
Fazlul, JLUL. 103 is my other card, my lord. 102 and 103.
You are in jail in connection with this case or any other?
This case only. Only for, my lord, this affidavit I have filed to clarification. This case only, nothing, no other.
But
case.
you have named your name is there in the petition is Faizul, FAI,
FAI.
and police forwarded you as Fazlul.
Fazlul. And original name is FAZLUL. So, my lord, I
So
have.
why you are naming your name you have mentioned as Faizul if you are FU
My lord, I have wrongly Fazlul and Fazlul.
in petition also?
In petition also, for which I have filed this affidavit, my lord, to clarify this fact.
Is Borba any other submission?
Yes, my lord. You will put it in.
103.
Lordship may kindly come to page number 15, my lord.
15.
15. 15, my lord, I am reading from page paragraph line numbers 5, my lord. on spot interrogation, my lord, that is, my lord, the person who is arrested, my lord,
Hmm.
Selimuddin, he admitted that the drugs had been kept concealed at the orange search chamber basement of the vehicle bearing registration number so and so, with a view to deliver deliver the same to one, namely Fazlul Haq, son of Sirajuddin, village so and so, Assam, with contact number so and so, my lord. He has given the contact number of the accused person, my lord, to whom my lord, the contraband was supposed to be delivered. My lord.
Supposed to be done.
Now, my lord, whether he was in hospital, whether he was in hotel, whether he was in somewhere place, that we are not concerned, my lord. Because, my lord, he may be sustained some injury, that is the different aspect of the matter, my lord. But, my lord, this contraband was brought to deliver to this person, my lord. Regarding, my lord, ground of arrest, my lord. My lord, what is, my lord, before coming into, my lord, this three judgment, my lord, earlier procedure was that, my lord, if ground of arrest is served, then, my lord, the grounds of arrest in detail, it was mentioned in the forwarding report, my lord. That is the procedure followed, my lord. After coming into, my lord, the my lord, the decision of the Honorable Apex Court, my lord, from Pankaj Bansal onwards to Bihan Kumar, my lord. That is clarified that, my ground of arrest has to be mentioned, my lord, in that also. But in this three, my lord, judgment, my lord, there is no mention whether if the person is, my lord, caught red-handed, then, my lord, whether, my lord, again, my lord, the ground of arrest specifically, my lord, the reason for why he has been arrested, that is has to be, my lord, mentioned or not, my lord. Because this was earlier, my lord, this was the procedure followed, my lord. It is not that, my lord, ground of arrest is not harnessed, my lord. Lordship will go by the, my lord, record of the all the cases, my lord. Lordship will find each and every case ground of arrest is mentioned, my lord. Only in the forwarding report, my lord, it is mentioned as the details, my lord. Mention the details, my lord. So why you have been arrested, what has been recovered from you, or under what circumstances you have been arrested, everything is mentioned, my lord. And these are, my lord, organized crime, my lord. Because, my lord, person brought contraband, my lord, and lordship may see the quantity, my lord. It's a huge quantity, my lord. Contraband, they carried the contraband to supply to somebody else, my lord. Now, my lord, when the person will be arrested, my lord, he will, when the police will interrogate, he will definitely, he will, my lord, mention. Now, in this case, my lord, even the phone number has also been given, my lord. That this is the person to whom, my lord, the contraband is supposed to be delivered, my lord. So this is my humble submission, my lord.
Lord, I have been implicated due to the animosity of others in my land dispute in our village area. For which, my lord, I was attacked, I got injury, and subsequently, my lord, my name is implicated by this Prime Hidus Salim, alias Abdullah, for which I was arrested to take the revenge and nothing else. But
There is no such materials in the search sheet, my lord. I have also perused the search sheet, my lord. There is no such materials, my lord. Due to some land dispute, my lord, the prime accused person has mentioned or implicated the, my lord, this person. And moreover, my lord, the search sheet case, my lord, sufficient materials have already been collected, my lord.
Heard Mr. H.R. Chaudhary, Dilaner Council for the petitioner, and also heard Mr. R.J. Borwa, Dilaner Conditional PP, appearing on behalf of said respondent. And this is an application, section so and so, in connection with so and so. Scanned copy of the case record has already been received by the district. It is submitted by Mr. Chaudhary, Dilaner Council for the petitioner, that he got arrested in connection with this case on 10/11/2024 from hospital, as he was admitted due to some injuries sustained by him on attack by some miscreants, by miscreants. But nothing has been seized from the conscious person of the accused petitioner, and he got arrested only on the basis of statement made by the accused persons with whom he has some land dispute or previous enmity. He is totally innocent and not at all involved in the alleged offense. However, he is in custody since 10/11/2024. Charge sheet has already been submitted. But is any witnesses? No.
No, my lord.
Charge has already been framed or not yet?
Yes, expect, my lord, I have to go through that.
not yet, my lord.
However, charge is not yet framed, nor any witnesses is examined by the prosecution till date. Mr. Chaudhary further submitted that at the time of issuing notice to the present petitioners under section 50 CRPC, as well as in the arrest memo and inspection memo, no grounds of arrest has been mentioned, so and so. Baki eta judgment ase, ya pata keta submission report. Next para, Mr. Burwa, the learned additional PP submitted in this regard, that from the forwarding report, it is very specifically mentioned that the co-accused persons who were arrested along with the contraband had specifically named the present petitioner to whom the contraband was supposed to be delivered along with his mobile number. He further submitted that a huge contraband was recovered from the possession of the co-accused persons. Record person, first of all, though it is a fact that there was no recovery from the present accused petitioner, but the entire case is, this is an organized crime wherein all the accused persons are fully involved in the alleged offense. Mr. Borwa further submitted that the grounds of the intimation of arrest was made to the petitioner while issuing notices and as well as the arrest memo and the inspection memo, and the entire ground of arrest is mentioned in detail in the forwarding report of the present petitioner. Mr. Moore, other commercial quantities. Okay, we'll pass the order.
My lord, and Fazlul and.
Oh, yes.
That
Ms.
may be-
A. Chaudhary for submission on Debo. He further submitted that inadvertently the name of the petitioner is mentioned as Faizul. And however, he is known as FAJ, no? FAJLUL by all his documents.
And FAZLUL.
And the police also forwarded his name as FAZLUL Fazlul and not by Fazlul FAJLUL.
No, my lord, police forwarded FAZLUL.
Actually, you are FAZ.
FAZLUL.
Uta kori dibo. FAZ is LUL and FAJLUL is forwarding. No?
My petition FAIJUL, for example.
Yes, that is understood. In that regard, he also filed an affidavit claiming that Faizul alias Fazlul FAZLUL alias FAJLUL are the one and same person.
Mine, bless.
Baki alias koi dibo please na. This person.
14.
Lordship, have a look at page 25, my lord.
25.
Page 25. Lordship, will see at the top, my lord. This is a forwarding report, my lord, dated 6 November 24, my lord. Today is, my lord, 182 days. Charge sheet most probably not filed.
The extension product made by the investigation officer, it was allowed on 23/4/25.
On
after 60 days.
23,
23/4/25.
extension prayer is allowed.
Allowed.
Now, my lord, in the instant case, my lord, the state has filed an affidavit. Now, lordship will turn to the affidavit is at page 41. Relevant parts, my lord, page 42. Paragraph 4, my lord. That the notice issued under section 47 and 48 of the BNSS contains the section under which the accused was arrested, but the ground for such arrest were not mentioned in the aforesaid notice.
Why they had to file the affidavit was direction from the
Yes,
court.
there was a direction from the court, my lord. Whether section 47 and 48 whether complied or not. So from the affidavit, it reveals, my lord, they have not complied with it. Ascend the directive 47, 48 notice.
ground of basis নাই আছে পলিসি নোটিস আছে
Notice is there, grounds.
নোটিস যে পলিসি গ্রাউন্ড অফ বেসিস নোটিস এই এফিডেভিটটা হেৰি দিছে আই দিছে
So therefore, my lord, this case is covered by your lordship, my lord. Yesterday's case, my lord.
otherwise recovery was made from the both the petition authorship. Nothing.
But extension is already there.
FSL is received them, FSL positive. They could not be taken the back the case diary because it was retaining order of the case diary was there by your lordship. That's why they cannot take back the CD. Pamaha go na they have a very good about two by.
Heard Mr. N.J. Datta, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Received. You have received the information that extension was there and FSL is also collected.
Yes, but he has sent me by.
Okay. So and so, and it is submitted by Mr. Goswami that FSL has already been collected by the IO, which has been sent to him. And further, as per
Which has been informed.
informed,
Informed him over
Okay.
WhatsApp.
informed sent informed that FSL has already been collected by the IO. And one extension prayer for extension was made before the learned special judge, which was accordingly allowed by order dated 23/4/2025. Post. In that context, Mr. Doctor, the learned additional BP submitted that. Otherwise, your submission, what is your submission?
My submission is that, my lord, section.
Recovery
47
was for him.
Section 47 and 48 not complied with. my lord.
No, recovery was,
Recovery was from the track, my lord, and I am Noor Alam, the present petitioner, is the, my lord, driver.
And he's accompanied him.
My lord. 26, my lord, same, my lord, same for madam 26 to
submitted that there was no.
sorry
conscious-
21.
There was
20.
no conscious recovery, no, there was no recovery from conscious possession of the accused petitioner. However, it is alleged that the contraband was recovered from the truck wherein the present petitioner was the driver.
My lord, Noor Alam is the handyman and item number 21 is the driver.
He is the handyman.
He is the handyman.
So 14 is the handyman.
Handyman.
Buliko, and he was not aware about any contraband if it is loaded in the said truck. Full stop. It will direct rate handed to none, Further, he submitted that in person to the order of this court, the state has already filed their additional affidavit, filed their affidavit wherein also it is specifically mentioned that though the notice under section 47 and 48 BNSS were served to the present petitioner, but no grounds of arrest were been mentioned in the said notices. Accordingly, Mr. Doctor submitted that admittedly there was no ground of arrest at the time of issuing notice to the present petitioner, as well as in the arrest memo and as well as in the arrest memo. So non-furnishing to ground to depot, same ground. And Goswami Pradipur, same depot, conscious position. He was the one of the occupant of the truck where from the recovery was made. That much. And you are saying 21.
21, yeah. 21 is the driver, man. Otherwise same.
In 21 also, you have filed your affidavit?
Yes, madam.
21 same order, FSL report, extension is there. To whose satisfaction this one?
My lord, this will be, my lord, a special judge, NDPS, Karbi Anglong, Diffu. Better, my lord, if your lordship quote that paragraph. If your lordship, the state's affidavit, the paragraph may be quoted. It will be good, but. Paragraph 4.
Okay, you have give that the quoting of the paragraph.
Yes, madam.
Para 4, na?
4.
Affidavit or para 4.
I am obliged, madam, deeply obliged.
Fifteen,
May please.
Yes.
My lord, regular bail application, my lord, under section 483, my lord. The
And
petitioner was arrested on 3/11/23, my lord, in connection with NDPS case, my lord. The allegation that
records is still awaited.
not received yet.
A record not received. Record is still awaited. Yep, the registry has taken steps, but it is awaited. Your petitioner got arrested when?
2023, my lord, already 1 and 6 months, my lord, completed, my lord. And not a single witness has been examined, my lord.
That has to be seen, otherwise we don't have the records here. Have you annexed any other charge sheet, other form or other thing? It's not there?
Come from Kamrup, my lord, for this may be given. my lord.
No, Kamrup is okay, but we don't have date, কেটে দিব পাৰিব। Kamrup Metro? 16, 16. We're listing it on 16. Issue reminder, registry will do the needful in calling the case record from the concerned court. Okay, we're listing it on 16.
Yeah, please.
Yes,
Along with 16, lordship, item number 24 also may be taken up, lordship.
16 with
24.
24.
Same diary.
Is this
16 is a regular bail application and 24 is an anticipatory bail application.
plus 24?
The diary was there, lordship, on the last occasion, lordship has called for the injury report. Lordship. Injury report is not received. Lordship, this petitioner here in item number 16, lordship, he is in custody for the last 55 days. Lordship. Lordship may come to page 10, lordship, that is the FIR. Past date was in 30th, please.
No, case diary was asked to be written and to call for the injury report.
Medical report we have not received yet.
Like in case of anticipatory bail, no problem, lordship, they are with, and lordship has protected them. But dear, this person, lordship, is for the last 55 days always in custody, lordship.
Allegation is of grievous hurt or what?
They have not mentioned anything in the FIR, lordship.
Previous of 609, 611.
Section
11.
1212 and 1211, lordship. One is only injury voluntarily causing hurt, and if 2 is there, lordship, voluntarily causing grievous hurt.
So medical report was essential, Mr. Goswami. Why it is not here?
Most probably, lordship, and no such injuries has been sustained. Lordship.
No, maybe.
Even in the FIR, lordship, they have not mentioned anything.
They were arrested on when? They got arrested?
This person, he is in custody since, lordship, Lordship was about to extend him yes, from 13-3 Lordship. On the last occasion, Lordship has penalty case and Lordship found that while he was taken in custody, Lordship, he flew away from the police custody and then again he surrendered, Lordship. On that ground, Lordship asked that let him remain for some more days. I think to be Lordship, maybe 55 days.
You only one petitioner is there.
Yes.
Others are, for the implement, they have appeared before the IO.
Lordship may consider the anticipatory bail on the receipt of the injury report. This one, he is already in custody for 55 days, Lordship. Lordship can consider it.
Heard Mr. M. Ahmed, learned counsel for the petition. Also heard Mr. P.P. Goswami, learned additional PP, appearing on behalf of state respondent. And in regards to merit, what do you want to say against this petitioner? There are merits.
Also there, they have attacked the police personnel and he fled away, taking the chance of UN pilot.
It is said, so and so. It is the case diary, this is an application on section so and so, in connection with so and so. CD is already written since last date, but Mr. Goswami submitted that he could not obtain the injury report from the concerned IO for the victims. In that context, Mr. Ahmed submitted that the accused petitioner is in custody since 13/3/2025, and hence considering his period of detention, he may be released on bail. I got sufficient opportunity to interrogate the present accused petitioner, keeping him in custody and hence keeping him in custody full stop. Further, accused being the permanent resident of his address locality will appear before the learned trial court below on each and every day to be fixed by the court. Oh no, not on each and every day. Investigation officer day. Sorry, it's not solicited. Next para, Mr. Goswami, the learned additional PP submitted in the regard. The sufficient implementing materials are available in the case diary against petitioner. And he is very much involved in the alleged offense. However, he fled away from the place of occurrence and subsequently he got arrested. Next part. Considering the submission made by learning counsel from both sides without going details of the merit of the case, length of detention considered very detail. Since before which court it is?
It will be CGM Lordship, Dorong Mongol.
To the satisfaction of CGM government. And what about 24? What are you saying? 24?
Let it remain Lordship there on anticipatory bail. Let the injury report come, Lordship.
Okay.
There is,
Absolutely. They have already appeared, Lordship, before the IO.
they appear. Very following.
And they have already appeared, but whether custodial interrogation will be
They
required?
appeared and statement already recorded. Lordship.
Hard Mr. M. Ahmed, and it's 24 case same. So and so case same out of same affair. And it is submitted by Mr. Ahmed that all the accused petitioners were already appeared before the IO and cooperated in the investigation, and their statement is also recorded under section 161 CRPC. They are further ready and willing to cooperate the IO in further investigation of this case if they are granted with the privilege of the arrest. Mr. Goswami submitted in this regard that all the petitioners appeared before the IO after obtaining the order of interim pre-arrest bail and cooperated in the investigation. The director considering so and so for the custodial interrogation may not be necessary. Okay, your interim was granted on which date? 2/4.
Lordship, it is
2/4.
2/4.
2/4 is hereby made absolute. Okay.
I oblige, Lordship.
Seventeen,
May I please, Lordship?
Yes.
In this case, my lordship, I am appearing on behalf of Rasmil Ali. He was arrested on 14/3/2025, my lordship, around 55 days behind the bars.
14 3.
14/3, he was arrested on 15/3, he was produced before the court. The case, my lordship, the incident relates to an incident of 2023, my lordship. The accused person and the victim were having a love affair between themselves. Subsequently, in the year 2023, she accompanied the accused person who is behind the bars to Guwahati due to his mother's illness, stayed with him for a few days. And subsequently, due to her minor age or major age, ring ceremony was already done, my lord. Marriage did not took place. Then Amina Begum, who is the mother of the this victim girl, she lodged an FIR on 27/5/2023 before the Sathebari police station. In the additional affidavit, I have annexed it, my lordship. This is the copy of it. Wherein it is in vernacular. Even vernacular. I have annexed it also. This is the original. Then the allegation is that there was a promise to marry. Subsequently, she did not marry. He did not marry, and things were there. This case was charge sheeted. The next, my lordship, the certified copy, I have annexed it also. You'll find the charge sheet. The charge sheet is submitted under section 406, my lordship. On 30th of June 2023, before the Learned Court of CGM Barpeta trial is there. This
In the basis of this affair,
This FIR. Charge sheet is also have annexed, my lordship. You will get
under section which?
406. Original is there, my lordship. I have annexed the copy also.
See, the girl went with him.
12/20. 406 is there. My lordship. FIR will itself is the main content. Ring ceremony, assembly, there, CS.
Of why she was accompanied with the accused to his house.
To his house.
And then
Mother was ill or something like that. Then again, they returned back after a few
the
months.
marriage
Marriage
took
did not
place.
take place, my lordship. Then what
And then
happened?
how Bustu Bahani Akit hoise? Means what? But if there is no marriage, I'm just asking whether there is a why 406 is there, that's
No,
what.
Bostu Bahini not promised to marriage, most probably.
Ah.
That kind of term, this.
No,
yeah.
Swali Joni.
Kept my
Or Doha.
household, and therefore he requested to rescue my daughter in favor of my daughter. Charge sheet will speak, my lordship. Charge sheet I have annexed.
So what about that 406 is pending?
Pending, my lordship. This is the same incident. Now, my lordship, what happened? Again,
You have annexed the present affair?
this present FIR, my lordship, at page 15, 16, 17, my lordship, of my bail application. This was filed on 12/6/2024. Before the Commissioner of Police, Guwahati. Earlier was filed by the mother. This is filed by the victim, Janmoni Begum herself. my lordship. Now she is married.
Her statement is recorded under 183 lordship. She has said that in the year 2023, she was when she was studying in high school first year, she was in a love relationship with the petitioner lordship. And at that time, he promised to marry made some physical relationship with him. But he was that kind of. And later on, he didn't marry, refused to marry, that's why. And for physical relationship, that's why they were blocks.
Earlier case, my lordship, this kind of allegation was not there by the mother. Subsequent FIR, my lordship will say, with all respect, on the Commissioner of the Police, it was lodged on 12/6/2024 and registered on 6/12/2024 after 6 months.
Registered, my lordship. I was called to the police station. I went there. I submitted what I had to submit, that yes, there was a ring ceremony before me. She was, that happened something, my lordship, in 2023-24. I could not marry. The earlier affair with the same content, my lordship, came, stayed. Mother also same, she has also stated same. But here, my lordship, one exaggeration is there. Learned friend has already said, physical relationship. Now, if it had been committed, she is a measure. Allegation is that it was earlier. But earlier affair, nothing is there. No whisper of that thing is there. So, my lordship, we have some reasonable ground to disbelieve this FIR. This content of this harassment, my lordship. Language is something like this. Outrage my modesty and having physical relations without my consent. Secretly, many times with bad intention. This kind of language has been used in the FIR. I am already arrested. I am in jail for last 54-55 days. I am in jail. Yes. Athebari, my lordship, that not marrying, promise to marry, not marrying case is already going on. I will have to face the trial also. Here, my lordship, if something happens also, yes, if she can prove or some evidence may be in future may be given. I don't know how it will come because nothing has happened in that 50 days. My statement is there. I have absolutely denied. Yes, I had come, ring ceremony was there. Marriage was about to take place, but did not. Now to teach me a lesson and put me behind the bars for the second time again. And that too on this FIR, my lordship, which was not lost before the police directly. It was before the commissioner of police. There is no bar, my lordship. I am not saying that. June 2024, it was lost. December 2024, it is registered. FIR itself at page 17.
Yes, you are appealing for his appealing. Yes, what do you want to submit? What do you want to submit?
Up to the submissions of the learned PP lordship.
Heard Mr. M. Garodia, the counsel for the petition. And also heard Mr. DP Usami, the learned additional BP, appearing on behalf of state respondent. And you are MS?
S. Not lordship on behalf of Dr. P. Agarwal.
S. Nag. S. Nag appearing on behalf of Dr. P. Agarwal, the learned amicus for the respondent number 2. This is an application so and so in connection with so and so. CD received, there is the same cardboard seat. So it is submitted by Mr. Garodia that the present accused petitioner is innocent and he is no way involved in the alleged offense. He further submitted that on the same set of with the same set of allegation and cause of action, one FIR was earlier lodged against the present petitioner, which is registered before Sortebari PS case number, and case has already been Sortebari PS and case has already been Sortebari PS case number is
Sortebari PS case number, my lordship, is
94.
94 of 2023.
Already registered Sortebari PS case number 94 of 2024 under section 120B. /365 public 342 IPC, and which is accordingly charge seated, and the present petitioner is facing the trial. Post up. Subsequently, on 12/6/2024, with this same set of allegation, we only introducing the outraging of modesty and physical relationship, the present FIR has been lodged by the victim herself. But the same FIR was registered only on 6/12/2024, that is after 6 months. He further submitted there is a fact that there was a love relationship between the victim and the present petitioner, but no such incident had happened as alleged in the FIR, and FIR and only to give harassment only for harassing the present petitioner. The subsequent FIR has been lost by the present victim. So, however, he is in custody since last 54 days, and thus there was sufficient opportunity to interrogate him by keeping him in custody. and hence further custodial interrogation may not be required. Next para, Mr. Goswami, the learned additional PP submitted in this regard that in the present FIR, it is this submitted that at the time of incident, the victim was a minor, and the minor, however, after she lost the FIR, after she became major, and apart from the other allegation, she also brought the physical relationship with her without her consent, and she also made her statement incriminating the present petitioner in her statement made under section 182 BNSS. Next para, MS Na, the learned amicus also submitted that admittedly the girl was a minor at the relevant time of incident, and she brought the physical relationship with the victim, and hence his prayer for bail may not be considered at this stage. Next prayer. Considering submission to be unavoidable, length of detention avoidable, allowed to go on bail. Okay, will be allowed to go on bail to whose satisfaction?
CGM Kamrup, Madam.
No, is a special case
No,
taking?
POCSO.
Yes, POCSO is just special just POCSO, I think.
Special just.
Kamrup, special just Kamrup Metro. Okay. You'll take it up, Friday. You take back this year.
Eighty.
Yes.
The regular bill application of chips.
18 not, we have not received a case diary.
Huh?
We have not received a case diary.
Oh.
It is 45 days lordship. Intermediate quantity lordships.
Intermediate.
Lordships. And lordship only it is less than 2 kg ganja was recovered from the possession of the son of the petitioner.
What is this small quantity?
1.980 kg.
1 point.
Less than 2 kg.
1 kg more less than 1 kg is the small thing.
Less than 1 inch small, and your 1.98.
9. Less than 2 kg lordship. So my lord, 45 days lordship behind the bar. Only ganja lordship.
From Laluk, Lakhimpur.
Since when you got arrested?
3 lordship, 22 March.
Heard Mr. M. Hawk, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. Poster it is submitted by Mr. Goswami that she did not receive, though this signal has been sent to the IO. Next para, Mr. Hawk submitted in this regard that the present accused petitioner is innocent. However, there is an allegation of recovery of 1.98 kgs of ganja from his possession, and he is in custody since last 45 days, and hence, considering his length of detention, he may be enlarged on bail. However, he is ready and willing to extend his cooperation in the further investigation of this case if he is granted with the privilege of bail. Next part, Mr. Goswami, the learned additional PP submitted in this regard that from the FIR and forwarding report, there are sufficient implication against the present accused petitioner, and the recovery was also made from the conscious possession of the present accused petitioner. Accordingly, he insisted to call for the case diary. Baki did not. To whose satisfaction it has to be?
Special judge lordships, Lakhimpur, not Lakhimpur lordships.
Lakhimpur, not Lakhimpur. Special judge Lakhimpur, not Lakhimpur. Okay, then.
No, the case is in the investigation stage, but scan copy was called for, scan copy receipt. In the order, it is called for a case diary. But received and scan copy. We have also communicated for a case diary, but we have not received a scan copy received.
Scan
But
copy.
last order, a case diary was called for.
Yes, case diary was called for.
And copy of CV.
Why
Can
scan
scan
copy
receive
was called for?
FSL, I have checked the scan copy, okay, FSL not received yet. And 54 days in custody, intermediate quality.
56 days.
Today is 56 days.
Today is 56 days.
But I can not
Say 50, whatever 56 or intermediate quantity lordship. And ground of arrest here is lordship, incarceration is there, and ground of arrest is not properly explained lordship. In this case, lordship. But this is,
Have you annexed this?
yeah, I have not, because I have obtained the certified copy lordship. If your lordship inclined, then I can supply this certificate.
recovery of 6.54 kg of ganja.
6.5. And not recover from my possession, lordship. Oh, what even in this case, the one person has been apprehended by the police personnel and recovered 6.500 kg of the suspected ganja, lordship, on 1st March 2025, lordship. Thereafter, after the 11 days, that this person has been arrested, that petitioner before your lordship has been arrested, suspected to be involved in this case. If so far concerned to the statement of the co-accused, then as per the Tufan Singh cases, lordship, statement of the co-accused is inadmissible. Moreover, lordship, in the Purakasta case also state clearly that this Section 47 notice that ground of arrest must be detailed, but which is not in the detailed form, lordship.
Some grounds has been communicated.
Mentioned, but these are not properly explained. I mean, that is submitting. Not communicated to the members of the family, but after the taken the custody, that my signature has been taken as per the my instruction, lordship. But not communicated to the my family members or the relatives, lordship. After taken my custody, then this signature has been taken in the police station, lordship.
And have you gone through the scan copy?
Yes,
FSL is not there.
Marked the 47 notice and arrest memo.
For FSL is not there.
FSL not there. And he was, later on, he was arrested. A recovery was made from other 2%.
Other 2 persons, yes, lordship. I have been arrested on 11/3, lordship.
11.
Have been able to.
Oh, 20. 56.
Mr. Arulva, the learned counsel for the petition. I also have Mr. BP Goswami, the learned additional BP, appearing on behalf of state respondent. This is an application, section so and so, in connection with so and so. CD was called for, but inadvertently, the office took steps for calling the scan copy of the case there, which has already been received. Where is this? Next one, it is submitted by Mr. Borwa, the learned counsel for the petitioner. That accused is in custody since last 56 days. 56 days. And his recovery was from him on and only 6.542 kgs of ganjas were alleged to have been recovered from the possession of the co-accused persons. So nothing has been recovered from the possession of the present petitioner, and he was arrested only on the basis of statement made by the co-accused, which is not at all admissible as per ratio laid down by the Honorable Apex Court in case of Tufan Singh versus so and so DD. Mr. Borwa further submitted that there is no proper grounds of arrest mentioned in the notice under section 47 BNSS, and the grounds of arrest are not even mentioned in the notice issued to his family members under section 48 BNSS, which is mandatorily required to be followed. And in that case also, Bihan Kumar request. Mr. Borwa further submitted that he is in custody since last 56 days and does the got sufficient time for his custodial interrogation. And accordingly, considering his length of detention also, his prayer may be considered. Next para, Mr. Borwa, Goswami Dilanet additional PP submitted in this regard that the position was not, recovery was not from the position of, admittedly recovery was not from the person of the present petitioner, but he was arrested considering on the basis of the statement made by the co-accused persons during the investigation and investigation full stop. He further submitted that there is sufficient progress in the investigation, but till that I could not correct the FSL. But even detail nazar considering the length of detention. To whose satisfaction this is?
Return to the special judge, Suniti.
You granted with bail.
Deeply organized.
Your certificate copy is.
Yes, yes.
Magdalene. Okay. Intermediate quantity lordship, the total recovery was 5.4 gram lordship with 5 numbers of plastic file lordship. If we exclude that 5 files lordship, it will come much less lordship.
No, this is the case of FSL report not received yet.
No, you are in custody since when?
Last 47 days.
Yes, Goswami, you need some time or what do you want to say?
Because we 5 files are there, lordship, inventory is lordship will kindly see with 5 files. We will exclude the weight of the 5 files, 5 numbers of file lordship, it will come much less lordship. It will be small quantity.
As per IO, he is a habitual offender. After releasing from the, he will do again this type of case.
No, that other reference are not given lordship, that is first case lordship.
But he has studied these things, yeah, from long 4 years, he has doing this same time in railway gate.
No previous record lordship, that is technically
Okay,
now.
then we call for the short date we can give.
Lordship, and this is for 47 days and the police has not done their part properly, lordship. It should be always the plastic vial should be excluded, lordship. Nowadays, this is a trend, lordship. One small
No,
number.
but inventory is also there.
No, it
If
is
in
small.
inventory, it is already separated or at where there is any prayer for certification of inventory is there. or-
5 number. Nowadays, the trend is going on, lordship, because code also doesn't check it, lordship. When small quantity is seized, lordship, it will become A, easily gets the bail. So, lordship, always lordship, wait with along with the plastic vial. Many cases we have seen, lordship.
Inventory here also. 5.4 grams quantity.
5 numbers of plastic vial. Earlier, lordship, what happened to the inventory? It always says that without the file, lordship. That prior to file in
No,
the.
weight should be taken in fact.
Well,
without it.
in the FIR, we see the total weight, and when inventory is made lordship, it is always without well, and the quantity comes much lesser lordship, excluding the plastic. This is the latest trend is going on. Lordship. In commercial also, we have seen many cases lordship, at the time of filing charge sheet or framing charge lordship, it comes to intermediate quantity lordship.
Here the inventory written as quantity is 5.4 grams.
Without,
With-
without,
five numbers of plastic vials.
this is the latest trend.
Seal and yellow paper envelope.
But there should be in fact, weight should be separated now.
So nowadays it is done before the CGM board lordship, but what lordship, cannot say this also lordship, openly in the court lordship. Lordship can understand it. Lordship. That should be taken care of. It maybe the crime is heinous one lordship, but the law must be followed lordship. That is the thing.
Otherwise, you are in custody for 47 days.
47 days. It will, we are very much sure lordship, it will come much less lordship. It will be A lordship. 47 days lordship for that at the filing of charge sheet, definitely it will be a lordship or in the charge framing time lordship. If argument is done lordship, it will be different lordship. I can 47 days ladies lordship and tomorrow election is also there lordship, but concert election. lordship.
Yes, Goswami and the
Yes,
submission.
The 5 point programs. That are in the order also it is not reflected without the violence. Only 5.5 programs from the content.
No, without the value mention my. Supervision নাই এইটো আগতে ট্ৰেইনটো এইটো আগৰ কিছুলো ধৰে সেপাৰেট কৰি দিয়ে আজিকালি চব হেনেকে থৈ দিয়ে টেকনিক মানে বস্তুটো খুব টেকফুলি নিদিয়ে
Waste pictures are also taken, also taken, but with vials, not without the vials.
47 days lordship lady considering that tomorrow election is also there lordship but it can be allowed at the point of time lordship will cooperate lordship.
She will again come, Goswami.
Again
Don't,
come.
don't worry. We'll again take her into the custody.
Lordship.
What to do? These things are going, and especially the ladies.
That is
They are fully involved now.
fully involved. Every nook and corner of the sun.
Yes.
Usually with babies and all lordship with babies lordship 1 or 2 babies are there.
One with
Yeah.
babies also there.
Oh, lordship.
Yes, babies. Also.
Used to carry clothes lordship there.
Yes. And
Common
with the
in railway
babies, they
station,
were
lordship.
inside the jail also with the babies,
Lot-
with
lot.
the infant babies also, they don't carry. But there are sufficient provision in the inside the jail also for baby carrying.
Not that, we are not taking to that ground nowadays.
No,
The initial.
that is there.
No,
That
no.
is there only.
In this
Some
day-
pregnant lady also, lordship, in the last stage of pregnancy, they are involved in this lordship. We have seen many cases lordship, that they get arrested lordship.
And when the was additional CGM was probably in
That was,
Tejpur, I think.
that was-
There was a gang of lady, 4 or 5 ladies were there. They
No,
used to do the thief, mainly, I mean,
So
they
pickpocket,
mainly committing the theft.
Oh.
So what their modus operandi is that 4 or 5 ladies enters into a, especially the, I mean, shops where this Mekhla Sadar and all these
all,
things are there for this mulberry silk and all. So 1 or 2 they used to see these things as if they are going to purchase, and in that moment 2, 3 other 2 they used to put the Mekhla Sadar in the packets and all. So these are the models of operandi for 4 or 5 ladies.
Or
So-
lot of pickpocket also, we also have that many cases. Lot of
Yes.
pickpocket in city bus, lot of ladies gang.
Yes. So gang was there. Ultimately, they are I mean, habitual offender. Many times they went jail, then came out and all. One time one lady was pregnant at that time. She has to went and no bail petition was also moved for her because everything is there only, and she delivered the baby in the jail premises only. When she came out again for the production, and I asked her that what is his name now. Male child was there. So she said that some Bhaskar or something was there. I just forgot now. Then I asked her that why don't you give his name as Krishna, because he is also in jail. So they are doing this some other sort of these days.
But past 1 or 2 months, we are releasing such persons who are engaging this business, whole business.
Yes.
Now, most
What
of
will be the
them,
consequences? Only God knows.
What will be the consequences? We don't know.
Only God knows.
now everyone will engage in this heroin business lots of
Mm.
maximum lots of from Bolgata and.
And we feel very sorry for this, the 9, 10, class 9, 10 students. They are also having these drugs and all. So every entire life is spoiled, in fact. That is why.
Every villages now.
Oh, no, that
Every
is also
district-
thing lots. Now it has entered in the villages also lots.
Yes, villages.
Remote village also lots. These things are going
these
on.
things.
Earlier ganja was there lots, but now this powder. has
Heroin
entered
powder is
there.
also there. I heard Mr. S. Puni, the counsel for the petitioner. I also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. City receipt, where is the same? It is submitted by Mr. Muni that the present accused petitioner is a lady and she is in custody since last 47 days. And only 5.4 grams of heroin was found from her possession with the 5 numbers of vials, plastic vials. But no separate weight of the suspected heroin was taken during the investigation, and including the vial, the weight was taken, which was 5.4 gram. Mr. Munir submitted that the weight of the contraband may become less, and it may be a case of small quantity. However, the petitioner is in custody since last 47 days, and hence considering her period of detention, she may be released on bail. Next para, Mr. Goswami, the learned additional PP, submitted in this regard that the present petitioner is an habituated offender, and it is a fact that 5.4 grams of heroin was seized, suspected heroin was seized from his possession, and along with the plastic vials. But in the inventory also, there was no separate weight was taken by the IO during investigation. Mr. Goswami further submitted that IO could not collect the FSL till date, though it has been already sent for FSL examination. Next para, considering the submission made by so and so, without going into the detail of the merit of the case. Well, I'll take a break this. Absolutely no. With detail of the merit of the case, I find it so and so. Okay, Mr. Munir, your petitioner will be on bail. To whose satisfaction?
Lordship, one unusual prayer, Lordship, because we're in session court, Lordship, it takes up to 1 or 1:30, Lordship, the bail bond. If Lordship, for the sake of election, Lordship, we consider CGM, Lordship, then we can, if we get the copy certificate, we can.
CGM may not accept it.
Not it accept, Lordship.
How CGM will accept means?
So in some
Because
cases,
one
Lordship, we have found, Lordship.
like regularly what happens in the first initial arrest, it was produced before the CGM and all, but thereafter, though definitely it is not a case of committal and all, so it will be up before the special judge only. In that case, I don't know. In that
We have
case,
to for the
again,
sake
if
of
it
election,
is,
otherwise, the record will go there, Lordship. Sometimes it happened earlier also, Lordship, by mistakenly, Lordship, that sometimes in place of special, that CGM comes, Lordship, in order. Then CGM accept it, Lordship.
no, it is from Kamrup only. And then, okay, special judge.
Much obliged, your Lordship, much obliged. Much.
Should record the timing 3 and 8. 3 8 is there. 3 8 is there. Then after that 7 and 22. 22 are defining was up till 20 the other ones. Okay. And 1 2 is there. Senior advocate is waiting. Okay, you can call.
Timing 3.
Sorry, madam, because of other court, I really engaged.
It's okay.
But in this case, madam, today 74 days, my lord, POXO 4. And last time notice was issued to fiber respondent POXO, my lord. Whether the report has come or not, but immediately on the same day, we have submitted a copy, my lord.
Do you have any instructions?
Report we have not received, my lord.
Report, last time we were asked to take
Yes.
any instruction if you
My lord,
can.
Can it be taken up at 2 PM, my lord, to obtain instruction? My lord?
At 2 p.m.
2 PM, my lord.
Okay, in that case, we'll pay pendant. Okay.
Item 8.
In this case, my lord, co-accused judgment I have given same, my lord, your lordships. Order is page 40. What was it? Yes, sir. Page 44, my dear friends. Same, my lord, same. One of the accused, my lord, 3 persons before lordship in the present petition. And that your lordship will find page 45. His name is Saifuddin, my lord. Same case number, my lord. Only one thing, my lord, only Badavu PS case number, it should be 169, it has written 59. Rest NDPS case, everything is same, my lord. Your lordship find this in
So out of same FIR, it's not the case of out of same FIR.
same FIR, man. It is same FIR. Everywhere it is written 169. In one page, my lord, because of that, my lord, I think it is written. Oh, for the same. It just, my lord, your lordship kindly see, yes, page 19, your lordship kindly see, my lord.
90?
19.
19.
19.
No.
The first you have to kindly see, my lord, page. My lord, page 13, FIR, my lord. Page 13, case number 1.
Second line.
Second line from top, district Koranganj, FIR number 169. Your lordship got it one. Left side one.
So it is 169.
169, it is 169.
So inadvertently, it was written as 159.
Yeah.
So it ought to be
That-
169.
So that they have filed an application there, madam, they got to be in madam, because they have
Acha.
explained this thing, madam. Session case same, madam, everything is same, madam. And in this FIR, your lordship will find 3 persons, my lord, that arrested, my lord, charge sheet for the page, you see. Just, my lord, the charge sheet is page 24, your lordship kindly, madam, page 24. Accused name is page 26. Your lordship, Fairal Hussain, number 1, madam. 26. Your lordship, what?
Serial number?
Number 1, page 26,
Khairul.
Fairal Hussain. Then page 27, top Mamon Mia, present petition, Mamon Mia. Then page 29, Nadir Hussain. Your lordship got it. Then your lordship find Sabia Bibi. Then page 31, Saifuddin, who's bail your lordship, Saifuddin. Page 31. Your lordship, page.
Yes, yes, I have. So now this is your petition for how many petitions?
Three petitions, madam. Only one, my owner of the vehicle, that is my page 30, Mrs. Sabia Bibi. She is not before your lordship, madam. Same case. Overnight.
My lord, so this is a such that case, my lord. So, my
Yes.
lord, there are sufficient materials collected against them, my lord. Secondly, my lord, in the ground of arrest, my lord, if the accused person put their his signature, my lord, that means he has understood. It can be presumed, my lord, he has understood why he has been arrested, my lord. Now, lordship may kindly see, my lord, the ground of arrest, my lord. That is page number 41.
Yes. It is not ground of arrest. Information. sir.
Notice informing, my lord, under section 50 CRPC, my lord, now it is 47, my lord.
Yes, it is an intimation. ma'am.
Intimating, my lord.
It's not a ground of arrest. ma'am. Page 41, my lord, annex 4.
Because, my lord, when they were caught red-handed, my lord.
No, that is not there. Your lord. That is also not there, ma'am. You are informed that you were arrested in connection with this so and so on.
Yes, my lord, you are hereby informed that you are arrested in connection with the above referred case.
The section of the case are non-bailable, you will be forwarded before so and so. And what if say, my lord, your lordship is mentioned from your lordship, if I take your lordship to page. Pabin Kumar, my lord, page 49, your lordship's observation in Pabinpur case time.
Oh, that is, my lord.
So that is, my lord, your lordship, is it a ground, my lord? Information on
But,
it.
my lord, in Purvipur case, my lord, he was not arrested red-handed, my lord. Whether
No, anyway,
Purvipur
I think, my lord, we stand on the
was
same
a case,
footing.
my lord.
And
He was arrested. He was forwarded, my lord. Then, my lord, while he was forwarding, my lord, forwarding code, my lord, directed him to give the ground, furnish the ground of arrest, my lord. Then he came to know, my lord. Till he was arrested, after that he was forwarded, till that, my lord, he was not aware, my lord, why he was arrested, my lord. So in that case, my lord, if, my lord, violation of article 22(1) is comes also, my lord. His lordship may, my lord, may presume that, my lord, yes, my lord, he was not aware of about the ground of arrest, my lord. Yeah, my lord, he was caught red-handed, my lord.
no, here, he would not written anything, that Your lordship kindly see what is page 41. Where is the court attended? It is, you are hereby informed that you are arrested. And then your lordship kindly see, then other one, arrest memo, page 42. Simple. There is nothing there, but in arrest memo also. Then inspection memo also, page 43. And your lordship money just about 49, page 49. My. Your lordship quoted my lord. Forty-eight. It may be iterated at the cost of repetition that there is a significant difference in the phrase reasons for arrest and grounds of arrest. Here nothing, neither reason nor grounds also. My. The reasons for arrest as indicated in the arrest memo are purely formal parameters to prevent the accused person from committing any further offense. For arrest that are formalities, my lord. These reasons, middle portion thereafter, these reasons would commonly apply to any person arrested on a charge of crime, whereas the grounds of arrest would be required to contain, your lordship got it, man, to contain all such details in hand of the investigation officer, which necessitated the arrest of the. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against the custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest which are general in nature. Nothing is there, my dear lordship has seen. And your lordship always considered, my dear, on the ground of clarity also, my dear. Same thing, my dear. Nothing, no, neither reason nor grounds, my dear.
Look, I have already submitted in a manner other case, my lord. That earlier, my lord, it was, my lord, the procedure was that, my lord, grounds of arrest is furnished, my lord. Thereafter, my lord, the details, my lord, under what circumstances or for what reason, my lord, he has been arrested, that is reflected in the grounds of arrest, my lord, in the forwarding report, my lord. So in this case also, my lord, if lordship will go by the forwarding report, my lord.
Is there forwarding?
It is there, my lord.
Forwarding
This
always
is my
there.
humble submission, my lord.
Forwarding what is given to the court, my lord, not to the person concerned. Here your lordships are very clear, my lord.
In the earlier petition, the earlier bail application,
Yes.
and he submitted it on the basis of some CD analysis, the other person were arrested. But here,
That is on merit.
but here on merit, they're arrested.
They are the passengers, my lord. The owner of the vehicle is not yet been, my lord. There, my charge sheet was filed, but the absconding, that's why my charge has also not been paid till today, my lord. And they are in
All the petitioners got arrested same.
and yes, arrested, my lord, your lordship, the 13/6/24. About 1 year, going to 1 month less than 1 year.
13/6/24.
24.
Not arrested on 13/6/24. Heard Mr. H.I. Chaudhary, the counsel for the petition, the learned counsel, learned seniors counsel assisted by Mr. I.U. Chaudhary, the counsel for the petitions, and also heard Mr. R.J. Borwa, the learned additional PP appearing on behalf of state responsibility. Baki 45 of it was page number 45, more or less case number, everything will be same.
Only
Only difference
169.
is it is Badarpur PS case number 159 is quoted. Actually, it should be Badarpur PS case number 168. No, mark for it is- it should be
169.
Sorry, 169. Not 59. but
No,
169. Next paragraph, Mr. Can copy receipt when case it is submitted by Mr. Chaudhary to London Senior Counsel that the accused petitioners are innocent and they are not involved in the alleged offense. They are only the passengers in the said vehicle from where the contraband was alleged to have been recovered by the police. However, they are falsely implicated in this case and arrested on 13/6/2024, and since then they are in custody. case has already been charge sheeted.
Yes. Not framed because some.
Charge sheeted on 9/11/2024, but charge could not be framed till date due to as one of the accused person is co-accused is still absconding, and for which the charge also could not be framed at till date. Till date. তাৰপিছত বাকী আপোনাৰ পেৰা 5 পৰা মোৰ ছেম থাকিব পেৰা 5 এইখিনি মই আপোনাক দি দিলোঁ পেৰা 5 পৰা মোৰ ছেম থাকিব ইন আইটেম নম্বৰ 46 গুছা মোৰ RJ বৰুৱাৰ সাবমিশনত আহক there is sufficient incriminating materials against the present accused petitions, and they are arrested and the contraband was recovered from the conscious possession of the present accused petitioners, wherein 23.361 kgs of yaba tablets were recovered, which is a commercial quantity. Okay, মই ইয়াক mark কৰি দিছো same submission থাকিব বৰুৱাৰ
My lord, Lordship may also
Yes.
mention, my lord, page number 38, my lord.
38.
My submission, my lord. Page number 38, my lord. Third paragraph, my lord, during the course of investigation. Then, my lord, harder, my lord. Harder, my lord. As per the statement of the arrested accused person, Khairul Hussain, Mamun Mian Nibir Hussain, the other accused person arrested who would be the receiver of the said narcotic drugs from the CDR analysis of phone number of Mamun Mia. It is found that he has phone contact with the phone number of so which belongs to Mohammed Saifuddin.
So they were supposed to deliver the goods to one Saifuddin.
Who was granted with.
That is why, my lord, he was not married occupant in the vehicle.
Yes. Mr. Borwa further submitted that the present petitioner is not only the occupant or the passenger of the said vehicle, but during investigation, it has also come to the light that these petitioners are fully involved in the alleged offense, and they were supposed to deliver the contraband to one Saifuddin for his onward transmission. বাকি যে মই পেয়াৰ নম্বৰ 8ত মই মাৰ্ক কৰি দিছো এইখিনিৰ পৰা এইখিনি মোৰ অলে সেম থাকিব from submission made by Mr. Borwa. Nine submission more or less dictates.
And my lord, they are a resident of Tripura, my lord, so there will be some strict conditions.
Condition is there one serviceman. One employee, I think, your lordship.
Same submission. There will be grounds of the register also. Page 45 of missile over 5. Okay, what that's it. Page number 45 of South Africa. No, the same thing. Page number. Item number
22 and 7.
22 and 7. 21. Yes. Yes. 22 along with 7.
Both are arising out of same FIR, Lordship.
Yes.
Lordship, may I kindly take up item number 7 first?
7. Actually, do it. 7, yes.
7. Here, your Lordship, may I kindly turn to page 57. This is the order passed by your Lordship regarding co-accused, Lordship. And they are on similar footing, Lordship, that no grounds of arrest were communicated to them, Lordship.
But is there any difference that these three petitioners from whom the bail was granted?
Lordship.
It was, the position was not from him, so Tufan Singh most probably was there.
So,
But here in your instant case, the petitioners
no,
also.
in that case, Lordship, another accused was there, Hare Krishna. Regarding that, the other accused, Lordship, counsel for the other accused submitted that part. I have not submitted that part. And in fact, if your
No, no,
Lordship
no.
see the FIR.
I'm asking you that whether there is your petitioner also got arrested on the basis of the statement of the co-accused
No,
or
no,
direct,
Manuddin was also there. He was also the occupant of that vehicle, Lordship.
your petitioner?
Yes, Lordship. So I have, that part probably is not coming in my case. So the driver was someone else, and this petitioner along with others, that order which I have shown to your Lordship, they were the occupant of that vehicle, Lordship. And that arrest memo and notice your Lordship will find page 55 and 56. Page 55, your Lordship will find circumstances, that part is silent, that PS case number that is there, GDNT reference that is not there. So no grounds of arrest. And in page 56 also notice of information. Here also no grounds of arrest. This petitioner, the order which I have shown, and some other persons were occupant of that vehicle, where that driver was there, Lordship, where he was carrying those articles. So they were not aware about those articles. That is my humble submission to your Lordship. And Tajuddin also same, he was also occupant of that vehicle, Lordship, that item number 22.
22.
Same, Lordship. And his forwarding also same page number 55, 56.
Yes, Purva.
No, they were all, my lord, arrested together, my lord. They were, my lord, this.
7 and 22.
Yes, Fazul Haq and Tajuddin, my lord.
Hmm.
They were also in the vehicle, my lord. That was notable find, my lord, annexer to page number 21, my lord. But also may read the, my lord, last paragraph, my lord, after leaving SPS, my lord.
Yes.
After leaving the PSSP Kolimbon sir informed over the phone call that the suspected person may be used alternate route. So complainant are directed to set up a Naka near BBCL immediately. Accordingly, complainant reached the Saudi Bill Devendra Nagar near BBCL, where SP Kolimbon sir SIP Rishi Ranjan De, IC Girish Guns WP along with the staff are already present there. At 8:45 p.m. The vehicle bearing number so-and-so was coming from the said road, that is BBCL road. Accordingly, vehicle was intercepted at Sauliville, Devendra Nagar near BBCL. With the help of the staff of the cordon the vehicle. Complainant noticed that 4 persons were sitting inside the vehicle, including driver. Thereafter, complainant informed the matter to OC Bodarpur sir, Bodarpur PS sir over the phone and requested him to come to the spot and to send me witness to spot the observing all necessary legal formalities, that is search and seizure, etc. Accordingly, OC Bodarpur PSR along with staff come to the spot. 2 persons were also come to the spot as witness. SP Korimgon sir understood them the purpose of call. Witnesses are so and so, my lord. After that, my lord, during interrogation, my lord, all the accused persons were, my lord, found together. Okay, it is a nature of commercial quantity, my lord. And Jando Beres document see page number 56, my lord. Accused person, my lord. Understand the Jando Beres, my lord, for what purpose he has been arrested, he put his signature, my lord.
In paragraph 13, Lordship, I have given that all other co-accused were granted bail. The case numbers I have mentioned, but not to burden your Lordship, I have not annexed all those Lordship. That all the accused are BA number is mentioned in paragraph 13 of my petition.
My lord, since Lordship has, my lord, preserving the sum of the orders of the after hearing the matter, my lord. My lord, that will also, my lord, on the same footing, my lord, because they were arrested, my lord, red-handed.
No, there were 6, 7 numbers or 8 numbers of the were reserved, and those were pronounced yesterday only. 6.
Almost in one of my case also.
6 numbers I have already pronounced regarding that court red-handed issue was raised by Mr. Kaushik also was there. So we heard at a length, and final outcome was most probably bail was granted.
Lordship.
That was it. Because we made an observation, simple, it may be wrong or rightly or whatever, but there was no such distinction, in fact, was made in those cases by the Honorable Apex Court regarding the court red-handed or subsequent arrest. It's not there. However, now the matter is pending. There may be some outcome of the case. That is.
My humble submission.
This is also court red-handed issue.
Court
Otherwise,
red-handed issue, my lord.
yes. Agora issue was not court red-handed. It will not be. Mr. Same, either 7 or 25 will same movies. 7 and 22. Heard Mr. A. Ahmed, the learned counsel for the petition. Also heard Mr. R.J. Bol, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is not a charge sheeted.
Charge sheet.
Charge sheet.
Charge sheet.
Scan copy of the case report along with the CD received. Where is this in?
The record
Charge
not
sheeted.
received.
Charge sheeted when?
Charge sheeted
My lord, in
lordship,
respect to item number 22, my lord, scan copy not received. My lord.
not received lordship.
7 is the motion item, my lord. Item number 22 is the, my lord, bail hearing.
Scan copy is not received.
Not received because when this matter first came up before your lordship that red-handed part was raised. So your lordship fixed it today that during this time we will hear the matter and we will decide the issue. Because I have annexed the certified copies in my petitions lordship. And therefore your lordship has simply fixed the matter today, lordship, item number 22.
Okay, then this case scan copy to nili hue part to party. And when it is charge sheeted, as per you, the case is charge sheeted on
Next charge sheet, dated 10/2/2025.
charge framed or not it framed?
Charge not framed, lordship, as per my instruction.
Submitted that so and so. And your petitioners got arrested when?
That item number 7 got arrested on the same day, 14/10/2024, both.
14/10/2024. Both the matters, I think. Because same day they were arrested.
Same day.
Submitted that the present petitioner মানে একই order হবো দুইটাতে got arrested in connection with this case on 14/10/2024 and the charge sheet has already been filed on 10/2/2025 but till that the charge could not be framed by the learned court below. Mr. Ahmed further submitted that this petitioner is no way related in the alleged offense and he was merely a passenger in the said vehicle, wherefrom the contraband was alleged to have been recovered. The recovery was not made from the conscious possession of the accused petitioner and petitioner. He was arrested only on suspicion as she was one of the occupant of the said vehicle. Mr. Ahmed further submitted that the other co-accused persons are already granted bail by this court and accordingly considering considering the case of the present petitioner in the same footing, the prayer for the petitioners may also be considered on the ground of parity. Next part, further Mr. Ahmed raised the issue of non-furnishing so and so. Next part, Mr. Borwa, the learned additional PP submitted in this regard that there are sufficient increment, the present accused petitioners are fully involved in the alleged offense. From the forwarding report itself, it is seen that they are not merely the occupant of the vehicle, but the contraband was carried by them to deliver someone. No?
No, they were coming in a vehicle, my lord. That information was received, my lord. They were, my lord, apprehended.
That from the vehicle so and so, and the prior information was received by the investigating officer regarding the carrying of the contraband in the said vehicle.
They have carried from Mizoram.
which were carried from Mizoram by the present petitioner, along with some co-accused persons. আৰু বাকীখিনি বৰুৱাৰ submission more or less same থাকিব ঠিক আছে no আৰু এটা issue দিব Mr. Borua further submitted that it is not a case that the accused petitioner were arrested subsequently, but the contraband was recovered directly from the possession of the accused petitioners directly and from conscious possession of the accused petitioners. Or Baki, a conscious possession of what we had discussed something na? In those judgment, you can put all this as constituent.
And my charge is submitted by the.
Yes, sir, already submitted. Rest part will be seen. Okay, for 7 and 22 will be disposed of.
Special just Sri Bhumi.
Special just
Sri Bhumi. Avla Your Lordship.
Time being 12.
Because I don't have the brief, it's the HOD is writing code number 3 from the morning, my lord. With item number 3 is going on, my lord.
Post number 3.
Oh, sorry, code number 6, item number 3. DV, my lord, sorry. Obvious.
Okay, we'll try to keep it on that.
At 2 o'clock, man. Obvious.
34 of the supplementary list.
30.
Yeah, please, your lordship. Yes, a regular bail application.
Yes.
In connection with FIR 111/2023. Your lordship, I have been behind bars for 601 days today now, your lordship.
601
days.
Hmm.
I was arrested on 12th September 2023. Your lordship, my prolonged incarceration has affected my fundamental rights today to right in liberty and to right to speed trial. Your lordship, for that I depend on two Supreme Court judgments. If you allow me, your lordship.
Just tell us, you are admittedly behind the bar since 12/9/2023, but
Yes,
what is the status of the case at present?
It's charge sheeted, ma'am, and so far 4 witnesses have appeared out of 12.
No. What is the status of the case? Whether it is
It's
evidence
charge
is already started?
Yes, ma'am.
How many
It's,
witnesses have taken?
4, ma'am.
4
out of 12.
out of 12.
Yes. Your lordship, if you kindly come to Muhammad Muslim at Hussein case versus state, if you kindly come to page number 17, para 23. It was by the Honorable Supreme Court. It said there is a fund, if you are there at 23, there is a further damage of the prisoner turning to crime. As crime not only turns admirable, but the more professional the crime, the more the honor is paid to the criminal. Incarceration has further deleterious effects, where the accused belong to the weakest economic strata, immediate loss of livelihood, and in several cases, scattering of families as well as the loss of family bonds and alienation from the society. The courts therefore has to be sensitive to these aspects because in the event of an acquittal, the loss to the accused is irreparable, and ensure that trials, especially in cases where special laws enact stringent provisions, are taken up and concluded speedily, your lordship. Now, if you allow me, I will also come to the judgment of Rabbi Prakash versus State of Odisha. This is in paragraph number 4, your lordship, if you are there. As regard to the twin conditions contained in section 37 of the NDPS Act, learned counsel for the respondent, the state has been duly heard. Thus, the first condition stands complied with. So far as the second condition, reconfirmation of the opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty, the same may not be formed at this stage where he has already spent more than 3.5 years in custody. The prolonged incarceration generally militates against the most precious fundamental right granted under our Constitution, Article 21, your lordship. And in such a situation, the conditional liberty must override the statutory embargo created by Section 37, 1B, 2 of the NDPS Act, your lordship. Your lordship, with due respect, I'm from a humble background from Manipur. My family has suffered a lot after my imprisonment, so it's upon your judgment, your lordship. I It's my humble prayer, Your Lordship.
Yes.
My lord, this is such that case, my lord, the accused person, my lord, they were arrested on 12/9/2023, my lord.
Hmm.
Then, my lord, searches submitted on 28/12/2023, my lord. 28/3. And as of today, my lord, I have perused the scan copy, my lord, there, for the prosecution has examined, my lord, 3 witnesses, my lord. But my learned friend has submitted that 4 witnesses examined, my lord. If PW4 is not available in the scan copy of the report, my lord. So my humble submission, my lord, that may be called for, my lord. Secondly, my lord, all the PW1, 2, and 3, my lord. PW1 is the informant, my lord. And PW2, 3 are the independent citizen witness, my lord. They all have implicated, my lord. Because, my lord, this petitioner, my lord, Apu Singh Song, along with, my lord, 2 other persons, my lord. They were coming from Manipur, my lord, carrying their contraband, my lord, 2 kilo, 100 gram, my lord, heroin. 2 kg, my lord. Then, my lord, they're supposed to deliver to 3 persons, my lord. They are Abdul Ali, Inamul Ali, Khalilur Rahman, my lord. These 3 persons, my lord, including the present petitioner, my lord, they were coming in a vehicle, my lord. And the contraband was concealed, my lord, inside the vehicle, my lord. Then, my lord, police stopped them, my lord. Then police interrogated, then they revealed that, my lord, they are supposed to deliver to these 3 persons, my lord. Then, my lord, police also went with them, my lord, to deliver to the place, my lord, where, my lord, they're supposed to deliver the, my lord, contraband, my lord. When police, along with the 3 accused person, my lord, reached the spot, my lord, then the other 3 accused person, they came to, my lord, collect the contraband, my lord. Then they all 6 were arrested, my lord. And there are sufficient materials, my lord, because, my lord, since the evidence has started, my lord, all the PW1, 2, and 3, my lord, I do not know what PW4 has deposed, my lord, but PW1, 2, and 3, they have implicated, my lord. So rigors of section 37 will come, my lord.
Your
And
Lord,
there is no, my lord, delay, my lord. Because, my lord, arrested on 12/9/2023, charged on 28/12/2023, and as on date, my lord, 4 witnesses examined.
Your Lordship, the undue delay has already affected my fundamental rights. Your Lordship, it is also a fact that I was present at the time of arrest, but I plead non-conscious awareness of because I was only a co-passenger, Your Lordship. I was not aware of the thing that was going on. I have mentioned that in the petition also, Your Lordship. And it's already been more than 600 days behind bars, Your Lordship. If you allow me today, the further delay has already affected my fundamental rights again, Your Lordship. If you kindly consider, I take it to your wise judgment, Your Lordship.
Nipapur, it was already asking. I will pass the order.
Much obliged, Your Lord.
Office of Nipapur, my friend.
35.
Maybe, Your Lordship. So the petitioner was arrested on 5/3, Lordship, and followed on 6/3. Lordship, and category is in between category, Lordship, as on today, Lordship, 62 days will be there, Lordship. Lordship, I am entitled to default bail, Lordship.
You are arrested on 6/3, 5/3.
5/3, yes, Lordship.
Forwarded on 6/3.
6/3, Lordship.
Today is 62 days.
Yes, Lordship.
Yes, do you have received anything here, Bora?
That, my lord, case that is lying before us, my lord. My lord, I may be allow some time, my lord. Let me come at 2 PM, my lord. We'll just confirm the whether any search is submitted or not. Only for that confirmation, my lord. Because my humble submission, my lord, is the case that is lying before us, my lord. So, my lord, it may not be possible because, my lord, the FSL report was yet to collect, my lord. That is why, my lord, probably
Then
the
it is may not be possible.
Then perhaps have
Suppose if his FSL report is yet to be collected.
Yes, yes, sir.
In
No,
that
that
case,
is- No, that is, Manoj, the last CD was updated on 22/3/2025.
yes,
Because
22/3, that is immediately after arrest, there was some, most probably, entry in the case day, and thereafter there is no such entry. So
You
one
must
can
get the
fix it at
information,
two.
Manoj, only sources submitted on that information, man, at 2. Man.
At 2.
23.
So it is an anticipated bail application lordship. FIR on page 16 lordship. The present petitioner name is Syed Ali lordship. Case that was called for lordship. Can they seek service to service to complete one? Service is completed lordship. Then amicus curiae has to be.
Service is completed.
Completed. lordship.
And case diary updated is also received. I heard Mr. B. Chaudhary, the learned counsel for the petitioner. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. Updated case diary has already been received. And it is also informed by Mr. Goswami that the notice is already served on the respondent number 2. Accordingly, I find it necessary to appoint an amicus to represent the respondent number 2. MS car number.
B Chaudhary.
Hmm?
Or Nita Chaudhary.
Lady.
Miss B Chaudhary.
MS B. Chaudhary be appointed as an amicus to represent the respondent number 2. Rest will do the needful. Yes, when it can be listed.
Petitioner is a juvenile lordship and a short date.
Petitioner is a juvenile.
Juvenile lordship, as per lordship, the PAN card that is on page 18 lordship.
So why you are approaching this court, juvenile, if he is juvenile?
There is no bar to approach lordship.
Or
anticipated
otherwise
bail.
also why you are approaching
Since-
this court?
Since police is after this petitioner lordship. That's why, because FIR lordship, his name is there. Actually,
Even if suppose he is arrested, if he turns to a juvenile, then definitely obviously it will be
yes, lordship. is
anyway
there.
when it can be
21 lordship.
20. 21/5.
Obliged.
25.
CD will be retained, na? CD be retained till exit of testing.
25 lordship, as per last order at 27/3/2025. Petitioner appeared before IO, recorded first statement. Here the interim lordship and appeared in statement also recorded.
You are on interim otherwise.
She married informant husband, second wife. That is
She married the
informant husband. Married with informant husband. So going to the statement of the husband lordship, she denied she refuses to that the marriage was accomplished lordship, and their relationship was there. But when the informant and her mother was from threatening purpose, threatening was the petitioner lordship, then she broke up the relationship. But later on, his informant husband again come to meet her lordship. She appeared in a statement recorded. She has to put everything here.
Where is the FIR? At page
FIR
7,
page 7.
translated. Heard Mr. L. Puflu, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD receipt. Barrister Simha. It is submitted by Mr. Gogoi that after obtaining the order of interim pre-arrest bill dated 27/3/2025, he already appeared before the IO and extended his cooperation in further investigation of this case. He is still ready and willing to cooperate the IO if she is a lady, na?
Lady.
If she if she is extended with the privilege of pre-arrest bail. Next para, Mr. Goswami, the learned additional PP submitted that the petitioner had already appeared before the IO and her statement is also recorded and cooperating in the investigation of this case. Next para, considering the submission made by so and so, comma, made recently available in the case diary and other aspects of the case, I find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner, and hence the order of interim dated 27/3/2025 is hereby made absolute with same terms and conditions.
Public.
26.
26, we have received the external services.
I am waiting for the response number two.
Response number.
I file a Ocalat number. Only 3 or 4 days me only allowed. I file a application of application.
No, case has already been charge sheeted, he is saying. Not charge sheeted.
Service-
None appears on call for the petitioner. Heard Mr. TP Kusami, the learned additional PP.
We have received the
So-
case diary.
And also heard your Mr. B. Islam appearing on behalf of the respondent number 2, and he has already filed his wakalat number. The registry is accordingly directed to reflect the name of Mr. Islam on the next date of listing. Further, Mr. Islam submitted that he needs some more time to file their written objection. Post op. Next para, Mr. Goswami submitted that CD is already received. You want to retain it or what?
If you know long that, then we will return it. Because they are not appealed.
Yes, they are not present.
Lordship,
In the meantime, he will file his objection, but a bit long date, I think 21, 22, 23 maybe. there.
23.
23. CD receipt based on 23.
Any other told that I have some difficulties.
25, 26.
25, 26.
25. 26/5/2025. CDB return accordingly, calling for a updated one. Okay.
27.
May I please?
CD receipt.
Okay, this is for.
Yes.
Apply at page 9, Lordship.
Is that page 9?
9, Lordship, and it's a real Lordship. Allegation was against 2 persons, 2 brothers, Lordship. But 2 was arrested and subsequently released on regular bail. Before your Lordship.
So you are representing one only accused. Accused number 1. 2 already got arrested.
Subsequently released on
Achha,
regular bail,
okay.
Lordship.
Yes.
There is some dispute, Lordship, as which is reflected from the FIR also, Lordship. At last person, the last part of the FIR matter was informed to the accused number 2, and he assured that the matter will be resolved, but allowed the accused number 1 to go away from whom? It's admitted in the FIR, Lordship. Lordship. He is a student also, Lordship, petitioner.
Yes, Mr.
Date of birth is 6/9/2009, Lordship.
6/9/2009.
4 months, 3 days left. As per FIR.
And he integrated the petitioner also.
Then if you other custodial interrogation of the petitioner will be required. That's the case of FOXO, so is she implicated in mention?
Yes, matter is submission. Yes.
I'm the father of the victim. So I have filed the FIR before the Lahorgarh Police Station on 11th of January 2025. Hence the FIR. So this said, my minor daughter who doesn't have completed the age of 15 years, and that said the accused person is 25 years old, who is married person and also has a one child. So this said, my minor daughter is facing several problems like mental diseases because the society are denying to accept her as a daughter. And that's the accused person who is living his life openly without any restriction. He doesn't have the right to ruin my daughter's life and living his life. Therefore, this my submission is that please dispose of this case and direct to the officer in charge of Lahorgarh Police Station and to immediate arrest the accused person.
Heard Mr. M.K. Hussain, the learned counsel for the petition, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of said respondent, and you are Mr.
J. Firdaus.
J. Firdaus.
Firdaus.
Firdaus, and also heard Mr. J. Firdaus, the learned counsel, appearing for the informant of the respondent number 2. It is submitted by Mr. Hussain that the present petitioner is innocent and he is no way connected in the arrest offense. His brother, that is the accused number 2, was arrested in connection with this case and he already released on bail by the learned trial court below. Mr. Hussain further submitted that due to some dispute between the parties only, the false and concocted allegations due to dispute between the parties only, the FIR has been lodged with some false and concocted allegation against the accused petitioner. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of pre-arrest bail. Next paragraph. Mr. Goswami, the learned additional PP submitted in this regard that the victim is a minor girl, and as per her death certificate, she was born on 6/9/2009 and not even completed 14 years. She fully implicated the present accused petitioner in her statement made under section 183 BNSS, and Mr. Goswami accordingly raised objection and submitted that it is not at all a fit case to extend the privilege of pre-arrest bail to the present petition. Next paragraph, Mr. Firdaus, the learned counsel appearing for the respondent number 2, submitted in this regard that He is the informant of this case, and his minor daughter is still suffering from physical and mental agony, and the agony full stop. The petitioner is a 25 years old person and 25 years married person, and we're having a child, and his daughter is only 15 years, not even 15 years of age, wherein the accused had committed such a heinous offense with her. He accordingly submitted that the petition may be disposed of with a direction to police for immediate arrest of the present petition. Next paragraph. Considering the entire circumstances of this case, materials in the case record, and especially the evidence, especially the statement of the victim recorded under section 183 BNSS, I do not find it a fit case to extend the privilege of pre-arrest bail to the present petitioner, and accordingly the same stands rejected. Your petition stands rejected. Okay.
The instruction was to be,
We have not received any instruction yet. Will comment is try to
Madam-
comment it.
No, not any receive any instructions from the IO.
My lordship.
Why? They may be busy otherwise, but this the election. may be-
the election, but police yesterday running, my lord, it is that information, to my information, yesterday, police has gone to the house of that informant, my lord, to my information, but they did not receive it, saying that we cannot go to High Court.
We have.
That is the information we got from our side.
I could not connect the IO. That's why from our office.
I don't know, better your lordship may appoint any school, that would be better.
Not.
Heard
Already
Mr.
74 days, my lord.
Yes, that's right. Heard Mr. H.I. Chaudhary, Dilanet Senior Counsel assisted by Mr. S.S. Ahmed, the counsel for the petition. And also heard Mr. D.P. Goswami, Dilanet additional PP, appearing on behalf of said respondent. First off, this submitted by Mr. Goswami that he could not take the instructions from the IO in regards to the service of notice on the respond number 2. So in that context, Mr. Chaudhary, Dilanet Senior Advocate, submitted that as per his instructions, his notice has already been, notice was refused to be accepted by the respond number 2. The next paragraph, in that the let an amicus be appointed to represent the respond number 2, and accordingly, yes, accordingly, we have appoint Mr. D.K. Bhattacharya to represent the respond number 2. Registry will do the needful. CD otherwise we have received, na?
CD, I don't know why it's open, no.
I don't need it.
CD not received.
CD not received.
Not received.
CD not received.
But CD was called for, I think.
Well, but it was come under motion column, lordship. That is the problem.
CD with a call or not, I'm not sure, my lord. Last order.
Oh, that is.
Your lordship
one
wanted to
update.
dispose, my lord, so that notice
Yes.
formality is to be,
Did
my lord, completed.
CDB call for. The possibility list the matter accordingly. You are under 74 days.
74 days. They let it be on not Thursday, my lord, Friday, my. Will you give comment to the
Thursday, Friday will not be serve the purpose. Thursday, Friday will do, Mr. Goswami. No, CD will receive by that time. From where you are now going to submit, because it is a case of POXO.
Lordship.
Unless we receive the CD, how can you submit? Maybe 13 or 14. I
Ultimately,
think.
about,
CD
my lord, it's only 10 months left to it, 18 years, my lord. And they had love affairs, my lord. It continued. Marriage also almost
Have
settled.
you annexed the this?
That notice also you have annexed, notice also annexed.
No, notice is all right. This oh, how will you annex this? 164 is
No,
also
that
not
we
available
cannot.
with you.
We don't have nowadays.
Yeah, you don't
We
have.
cannot.
You don't have. Huh? Pardon? Maybe $14. One. Full item number case. 1/4 maybe, no?
Obliged.
Much.
Copy, DK what you mean? Who knows? DK what type of- Copy is to be given, my. So name of DK may come in the.
Yes,
copy.
we have already reflected.
Item 12, fixed to
I'm sorry, but I was not there in the first half.
Yes, you were there somewhere.
Okay. Malad, here it's a Malad, 480p application for grant of pre-arrest bail, my lord. Here. the
Grant of pre-arrest.
Pre-arrest, my lord. The
We have received the case, right?
It's a motion matter.
Oh, it's a motion column. Okay.
Sorry, no problem. Oh, it's a motion, my lord. Malad, here, Malad, because Malad,
Last item.
regular bill, we all filed before this honorable court, my lord. Here, my lord, page 17 is the FIR, my lord.
17.
17, my lord. No problem. Yes. Here, my lord, lawsuit find, my lord, it was lodged on 28 to 2025. And the FIR alleges, my lord, there was illegal trading activities by Sinmoy Das, my lord, and his family members. Now, my lord, lawsuit find that the names of the accused person, number 1 happens to be the prime accused, and number 2 is before lordship, he is the happens to be the father of the prime accused, my lord. And race, my lord, that Bina Das, my lord, she is the mother, my lord. She has been granted the privilege of anticipatory bail. Then 5 or 4 also, my lord, Deepsika Boiso. She is the daughter-in-law, my lord. She has also been granted the privilege of pre-arrest bail. My lord, because they happens to be a family members, they have been roped in the whole scenario, my lord. Now, my lord, if your lordship kindly have a look, my lord, lordship, that 4th line, regarding illegal trading activity carried by Sinmoy Das and his family members along with his companies in my locality. There, Mr. Sinmoy Das collected funds from me. Next page, lordship kindly see. So Sinmoy Das collected funds with a promise of high returns, but showing these and those, he trying to cheat me. And today, while I approached to him requesting to return my funds, he misbehaved me and threatening to kill me, assaulted me. Then a situation. So, prima facie, lordship find that money was collected by Sinmoy Das, and the informant he went to Sinmoy Das, and Sinmoy Das, my lord, did not return the money, and there was some altercation between and threatening. Now, so far, this next para, my lord, what is against us, my lord. Furthermore, it has been observed that Sinmoy Das not acting alone. His family members are involved in collecting funds and this kind of criminal activities like father. So same allegation is the mother also, his wife also, my lord. They have been granted the privilege of anticipatory bail. Now, my lord, one line, lord, you kindly see that last but first one para, my lord. Sinmoy Das and his companions' actions are not only unethical, but may also constitute. So there was an apprehension that it might also constitute a criminal offense, my lord, criminal behavior. Since disappearance, because he disappeared, my lord, Sinmoy Das, my lord. Now, my lord, next page, lord should find details of bank accounts, my lord. Here, lord should find bank accounts of, it has stated regarding Sinmoy Das and his mother, my lord. Kindly see, Bina Das. Bina Das is on anticipatory bail. Now, my lord, what happened in this case? The Sinmoy Das, the son of the present petitioner, my lord, he collected money from the first informant. First informant name is one Amar Das.
Yes.
So first informant name is Amar Das, my lord, and the prime accused is Sinmoy Das. Kindly see page 21, my lord. We have given the chart along with the bank statements, my lord. All bank statement we have given. So lordship would find that here in that page, my lord, Annexer B, 14 lakhs 5,000 was credited into the account of the present petitioner, my lord, the son of the present petitioner, Sinmoy Das. And thereafter, my lord, kindly see what was debited back, my lord. 14 lakhs came and 22 lakhs already returned back to the informant by the son of the petitioner, my lord. And next page, my lord, another account we have given. Here also, my lord, that chart we have given, and we have narrated this in our paragraph also, my lord.
That
Now,
paragraph,
how can
my
you
lord,
say that these were returned back?
because investment, my lord, debited back to the account of the informant.
How? How can you say this?
Yes, yes, no, kindly see, my lord, that I will show one document. Lord, you may see, kindly have a look at, my lord. Page 25. There are two amounts, my lord, came. Again, it was returned back that 7-2 lawsuit fine once, my lord. It was credited from Amar Das into the account of Sinmoy Das, my lord. 7/2/2024, my lord.
Seven to 24.
So really, I have given all this, my lord. This, my lord, and this chart we have given, my lord, while we move the regular bail application also, my lord. This because Sinmoy Das we moved, my lord, before this honorable court. So this is the chart given, my lord, and we have made statement also. So transaction were prima facie between Amar Das and Chinmoy Das, the son of the petitioner, my lord. The two bank accounts we have given, my lord, with along with the charts, my lord. And now, my lord, my bank account, the petitioner's bank account details we have given, my lord. That is page 106, my lord. Not a single penny came into the account of the petitioner from, my lord, Amar Das informant, my lord. And, my lord, that Chinmoy Das bail order kindly have a look at page 128, my lord. He was in detention, my lord, for some period of time, so he was granted bail, my lord, regular bail, page 128. Then, Lord, should kindly see at page 129, my lord, para 6, my lord. Learned counsel so-and-so, Sinmoy Das has submitted that the allegation so-and-so true is absurd. The petitioner has received money and the transaction are shown at Annexure G of the petition. The bank statement clearly reveals that the money has also been paid back to the investor. Money was transacted through so-and-so app, which is registered under SEBI, and this is not a case of illegal trading. And, my lord, para 7, progress of investigation, he was granted the privilege of bail. Now, my lord, here, my lord, Lordship may kindly see, my lord, to be fair enough, my lord, we moved the, my lord, Larned Sessions Court, my lord, and, my lord, Sessions Court was pleased to allow the bail of the mother, my lord, but was pleased to reject my bail application, my lord. And Lordship may kindly turn to page 29, my lord, the rejection order, my lord. Here, my lord, what happened, my lord? The IO, my lord, in the case diary, he stated the bank statement of the present that fifth para, my lord. CD reflects, my lord.
Your pagination is very different.
126, my lord.
126.
My lord. That's what's seen, my lord. My lord, here, my lord, that fifth para, my lord. My CD reflects, my lord, also seen, my lord. That IO has collected bank account statement jointly held by Bhupen Das with Chinmoy Das. Bhupen Das is before lordship, my lord. Perusal of the account statement reflect credit of various amounts. So, my lord, here, possibly it is not a true fact because, my lord, Lordship, kindly turn to, my lord, page 124, my lord. I do not have any joint account with my son, my lord. Those two accounts I have, my lord. Lordship, kindly turn to 124, my lord. There, Lordship, find, my lord. I submitted this letter before the, my lord, branch manager Axis Bank, my lord, requesting, my lord, kindly see, my lord. Through this, I am seeking clarification from the respective authority about my accounts at our bank. I am currently under an accusation in connection with so-and-so, this case, my lord. The case needs certain authorized clarification from your end for my different point of view, that is language, my lord. The case diary of the aforementioned mentioned case reflected that the investigative officer had collected joint account statement of me along with my son Chinmoy Das. Also agree. Following are the accounts which need the accounts holder name to be clarified with so and so. So this
I filed, my lord, and the letter given by the bank, my lord, kindly have a look at page 125, my lord. This is to certify that Sinmoy Das, who is bearing the below mentioned accounts with Axis Bank Airport, is an individual account and it is not in a joint holder capacity with his father. So Sinmoy Das, no joint account with the present petitioner, my lord. And my lord, here, my lord, what happened, my lord, to be fair enough, my lord, that my son, my lord, he was into this online trading, my lord. So online trading itself, it is not illegal, my lord. If it is in a regulated market, my lord, like security market, my lord, like they do it with this app, my lord. There's a Dhan app, my lord. Through have Dhan app, he used to do the business. And the investors, my lord, all person who intends to invest there, my lord, they have to give their, my lord, PAN card, Aadhaar card, voter, then, my lord, KYC, and they have even have to give their, my lord, that face identification, my lord. In webcam, my lord, picture has to be given. So now here, my lord, what happened, my lord? Lordship knows, my lord, my friend also knows, my lord. Lordship also dealt with all the cases. All unregulated deposit cases, they went to CBI, my lord. Lordship knows all cases. This case not, it is still with Assam Police because it is regulated deposit, my lord. Because it is Indian security market, there is no illegality, my lord. Anybody can invest there, my lord. It has to be through account only, my lord. And here, my lord, that section what they have attributed, my lord, of the Bads Act, my lord, that possibly with my limited understanding, that may not be, my lord, attractive because that section 4, my lord, that relates to unregulated deposit. Should I will place?
No, it's okay.
So, my lord, here section 4(3) relates to, my lord, that is unregulated deposit scheme. That is non-bailable. Violation of section 3, it is 21, that is non-bailable. It is a fact. Now, my lord, 4, my lord, 4, it states, my lord, fraudulent default in regulated deposit schemes. Even for argument's sake, my lord, if my lord, we do admit that my son did it and I also did it, even for argument, my lord. Here, my lord, may I read it now? No deposit taker, while accepting deposits pursuant to a regulated deposit scheme, shall commit any fraudulent default in repayment or return of deposit on maturity or in rendering any specified services promised against such deposit. So regulated, my lord, fraudulent default in regulated deposit scheme, that is section 4. And for violation of section 4, punishment is provided under section 22, my lord. So 22 states, my lord, that, my lord, any depositor who contravenes provision of section 4, that is, my lord, punishment for which may extend to 7 years. And, my lord, this is more very important, my lord. As per, my lord, that section 28, my lord, offense is bailable, my lord, if it is a regulated deposit scheme, my lord. So now, my lord, father, my lord, and we have shown, my lord, from documents that no money came to his account, my lord, and that there is no joint account. The prime accused is on bail, my lord, and he's around 65 years, my lord. He will appear before the IO and will place all these documents if necessary, my lord. Can you protect him? 65 years, my lord, of age, my lord.
The entire allegation against one of the petitioners, the Sinmoy Das. But that's it. At this stage, okay.
I'll appear and give all documents, my lord. 65 years, 64 years, not 65, my lord. And all are on bail, progressive investigation also, my lord, kindly, my lord.
Heard Mr. H. Chaudhary, the learned counsel for the petitioner. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application of section so and so in connection with so and so. It is submitted by Mr. Chaudhary that the present accused petitioner is innocent and he is fully connected in the alleged offense. It is a fact that in the FIR, all the family members of the present petitioner has been implicated in this case, including his wife, son, and other one is daughter-in-law.
My lord,
Other one is daughter-in-law.
his daughter-in-law, yes.
Daughter-in-law. Full stop. His son has already been arrested in connection with this case and he already got bail. And the other, the family members, that is the accused number
3 and 4.
3 and 4 are already in pre-arrest bail, granted with the pre-arrest bail. Further full stop. Mr. Chaudhary further submitted that the that from the bank statements and the accounts also, it is seen that the present petitioner, there's no money will be deposited in his account, nor no money was deposited in his account, nor he has any joint account with his son
Right.
as held by the learned trial court below while rejecting the order of bail for the present petitioner. In that regard, he applied for a certificate from the bank, wherein also it is informed, and as for the certificate issued by the bank, he has no joint account along with his son, Chinmoy Das, with him, who is said to be the prime accused of the entire case. Next para, Mr. Chaudhary further submitted that this this case is also not abstractly section 3 of the Buds Act 21.
21 is the punishment.
21, section 3, section 21, 21 of the Buds Act. And at best, section may attract, the case may attract the section 4 of the said act, which is also a bailable offense. However, the petitioner is ready and willing to cooperate in the further investigation of this case if he is granted with the privilege of bail. Privilege of pre-arrest bail. Next para, Mr. Samiri learned additional PP submitted in this regard that there are the specific allegation brought against the son of the present petitioner. However, as per the FIR, the allegation against the present petitioner is also brought, and accordingly, he insisted to call for the case time. Again, considering the submission political, so on perusal of the annexures. Okay, you'll be under interim protection. Yes, when it can be called for?
28.5.
20?
28.5.
28. CDB call for 28.5, abide by all conditions.
Hello. Highly obliged, madam. Much obliged.
Five of the supply list.
35% charge sheet pending. Charge sheet not submitted yet.
Not charge sheet. You are 62 days, huh? Hard Mr. S. Hawk, 35, no? 35. Hard Mr. S. Hawk, the learned counsel for the petitioner, and also hard Mr. Sorensu. And this is a case, this is an application on the section Sorensu in connection with Sorensu. It here we received the CD also.
To send back the case.
CD received. Where is the same? It is submitted by Mr. Hawk that the present accused petitioner is in custody since. When you are in custody since?
6/3, Lordship, 6/3.
6/3, 2025, and today he is his and he already completed his statutory period in the custody. Accordingly, he entitled for default pay. Next part, Mr. Goswami submitted in this regard that CD received, but from the perusal of the case diary, it is seen that the FSL is yet to be collected by the IO, and on inquiry made by him, it is intimated by the investigating officer that charge sheet is yet to be filed by the IO. So without going into detail, so and so, considering the length of detention, where it has to be?
Lordship, special just Bongao.
Special just
Bongao.
Special just Bongao.
Obliged, Lordship.
Okay.
For orders, item 28.
None appears on call for the petitioner. Release the matter accordingly after 1 week. As on a date to be fixed by the registry.
For Giri, item 29.
None appears on call for the petitioner. Release the matter accordingly for hearing after 2 weeks.
30.
The conviction under section 498A, my lord, and the learned trial court convicted sentenced for 3 years, my lord. Thereafter, in April, it was reduced to 6 months. And during the investigation, my lord, he was already there for 3 months, my lord, 94 days, my lord. Now, before going into the evidences, my lord, what I would like to point out, my lord, if my lord comes to page 25, my lord. That is
No,
the
it was reduced to 6 months.
6 months.
So during investigation, how many days he was in jail?
3 months,
3 months.
94 days to be precise.
I guess who is appearing here? Pardon? No, no, yes, yes. You are, Gusam, you are appearing. So now you are saying that it was a case of 2 years? Initial punishment?
Yes, 3 years, my lord.
Oh, sorry, 3 years?
Then it was reduced to, my lord, 6 months. During investigation, he was there for under custody for 94 days.
3 months. Plus.
Oh, 94. There was no valid marriage between the informant and between the wife and the informant is the wife. There was no marriage, my lord. That can be evident from the finding of the court, my lord, at page 25.
No valid marriage.
No, because the girl was of 14 years, my lord, at that moment. And the boy petitioner before lordship was 20 years. Page 25 of my petition may be kindly seen. Paragraph 13. On close and careful scrutiny of the evidence on record of the prosecution, it appears from the evidence on record of PW 1 and 2 that the accused demanded cash amount of so and so to the complainant, and failure on her part to meet up the demand, the accused started physical torture upon her and drove her out from the marital house. And this is important. It also appears that no formal marriage was performed in between the accused and the complainant. But this line itself, from here itself, my lord, the 498A conviction under 498 we cannot be sustained, my lord, because there was no marriage between the parties. And going, but the fact of living together as husband and wife for last 1 month by the complainant and the accused is not disputed by the accused. PW 1 and 2 have also exaggerated in their evidence that the accused made an attempt to commit mischief by setting on fire the dwelling house of the mother of the complainant. In the FIR, my lord, 406 was also 436 was also there, but charges were not framed under 436, only 498A. So regarding, there were some allegations in the PWDs that they have made an attempt to burn the house, but charges were not framed under that, only 498A. And my lord, from this line that there was no valid marriage between the parties, my lord, then 498A is not attracted, my lord. In to that regard, my lord, I would like to place some judgment. Also takes the Supreme Court judgment, my lord. Next page, my lord. I've marked there with a red color, my lord. With red color, I marked there. There may be considerable force. I'm reading from there, my lord. There may be considerable force in the argument of so and so, learned counsel for the appellant, so far as the conviction under section 498A is concerned, in as much as the alleged marriage with Mohini during the subsistence of valid marriage with Kalindi is null and void. We therefore set aside the conviction and sentence under section 498A. There, my lord, what had happened, my lord, during the subsistence of an earlier marriage, the accused, my lord, he married with some married second time. But as per Hindu norms, law, my lord, the second marriage is not void, is void, my lord. Therefore, the 498A was conviction under 498 was set aside, my lord. And in the order of our High Court, my lord, there also it is same. If my lord comes to page 3, second paragraph. Am I with a loss? Page, page 3, second paragraph. He further submits it 498A. Second paragraph. He further,
Yes.
He further submits that section 498A of IPC is only attracted against the husband or relative of the husband, and in the instant case, the petitioner is not the husband of the informant. Then, my lord, relying on a judgment, my lord, at page 7. U. Sovetha versus State. 2009. Page number 7. There are the ingredients of 498A. The first ingredient is the woman must be married. And relying on this judgment, the Honorable Single Judge at page 9, in the present case, the petitioner is already married to another person, and as such, the ingredients of section 498A prima facie is not made out. That after 498A was struck out. So my humble submission before your lordship at this moment, my lord, that there was no void marriage between the parties, my lord, and therefore 498A is not attracted. Before going into the evidences, my lord, this is the point of law, my lord, that has to be determined. That is the sum and substance, my lord.
Yes, who is appealing? Goswami or Borga?
Concurrent filing.
No, no, they also will. Just one part one. Then it will take time. In this case, then please start to that is correct. Yes.
My lord, he was convicted by under section 498A, my lord. So, my lord, the ingredients of 498A, my lord, also may kindly say. I'm not reading the, my lord, entire section, my lord. For the purpose of this section, 12 means, my lord. This is important, my lord. Any willful conduct.
No, my lord, let him read from the beginning, my lord. That will clear things.
Look, I am reading 498A, my lord. Husband or relative of husband of a woman subjecting her to cruelty, my lord.
There itself, my lord.
Whoever being the husband.
It has to be a husband, my lord. There has to be a marriage.
No, please, let me submit first, after that you will reply. Whoever being the husband or the relative of the husband of a woman subject such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years, and it shall also liable to fine, my lord. For the purpose of this section, cruelty means, my lord. These are the two ingredients, my lord. Any willful conduct which is of such nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, health, whether mental or physical, of the woman, my lord. Even, my lord, if somebody is, my lord, mentally harassed also, my lord, that will also amount to cruelty, my lord, apart from, my lord, physical harassment, my lord. Now, the second one, my lord, harassment of a woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security or is on account of failure by her or any person related to her to meet such demand, my lord. Now, my lord, in this case, my lord, from the evidence of PW1, my lord, this is the victim grant, my lord. The husband tortured her, my lord, demanding money, my lord. So may I take your lordship, my lord? My lord, paperwork is I'm handling, my lord. So I'm just reading the vernacular PW1, my lord. যোৱা বহাগৰ 1 তাৰিখে আছামীৰ লগত বিয়া হওঁ বিয়া হোৱাৰ পিছত স্বামীৰ ঘৰতে থাকিব লওঁ স্বামীয়ে মোৰ মাৰ ঘৰৰ পৰা টকা 20,000 দাবী কৰে মানে টকা দিব নোৱাৰাত মোক মাৰপিট কৰে মোৰ স্বামীয়ে মোক এদিন কাপোৰ কানি উলিয়াই দি ঘৰৰ পৰা খেদি পঠায় সেইদিনাখন সন্ধিয়া মোক মায়ে থবলৈ আহে তেতিয়া আছামীয়ে কয় যে যদি মই স্বামীৰ ঘৰত থাকো মোক মাৰি পেলাব বুলি কয় This is my own mental harassment, my lord. ঘটনাৰ দিনা পুলিচ ডিউটি কৰি আছিল মই তাৰ পৰা গুচি আহোঁ পিছত আছামীয়ে হাতত দা এখন আৰু প্লাষ্টিকৰ বাল্টি এটাত পেট্ৰল লৈ আমাৰ মাৰ ঘৰত আহে আৰু মোক ঘৰৰ পৰা উলিয়াই দিবলৈ কয় নহ'লে ঘৰটো জ্বলাই দিব বুলি কয় মই ওলাই আহোঁ আৰু আছামীয়ে দোকানলৈ লৈ আহে মোক আৰু মোক ৰুমৰ ভিতৰত নি পেট্ৰল ঢালি ৰুমত জুই জ্বলাই দিয়ে ডিউটিত থকা পুলিচে মোক ৰক্ষা কৰে তাৰপিছত পুলিচে দলং এখনৰ পৰা গ্ৰেপ্তাৰ কৰে ঘটনাৰ পিছদিনা মই গোচৰ দিওঁ মোৰ কাপোৰ কানি জ্বলি চাই এক্সিবিট 1 মই দিয়া এজাহাৰ এক্সিবিট 1 মোৰ চহী পুলিচে আমাৰ ঘৰৰ পৰা প্লাষ্টিকৰ বাল্টি এটা চাৰ্ট পুৰা যোৱা চাৰ্ট আৰু কাপোৰ কেইটা জব্দ কৰে মই জব্দনামা 2ত চহী কৰোঁ এক্সিবিট 221 হিচাপে এক্সিবিট 1 প্লাষ্টিকৰ বাল্টিটো এক্সিবিট 2 মেটেৰিয়েল এক্সিবিট 2 মানে this is something litter or something মানে এক্সিবিট 3 পুৰা স্কান্ট এক্সিবিট 4 শার্ট এক্সিবিট 5 হোয়াইট শার্ট এক্সিবিট মেটেরিয়াল এক্সিবিট 6 ব্যাম্বু স্টিক নাও মাই লর্ড ক্রস এক্সামিনেশন মোৰ বৰ্তমান বয়স 24 বছৰ হ'ব মই নিজে ইচ্ছামতে 24 মাইল এইটো 24 নহয় জানো 14 মোৰ বৰ্তমান বয়স 24 বছৰ হ'ব মই নিজে ইচ্ছামতে বিয়া হওঁ 24 বছৰত যে বিয়া নহয় মই জানো It should be my lord, maybe 14 my lord. 14 my lord. That is why my understanding probably correct my lord. সত্য নহয় যে ঘটনাৰ দিনা মই নিজৰ ঘৰত আছিলোঁ সত্য নহয় যে মই মিছা সাক্ষী দিছোঁ সত্য নহয় যে আছামীৰ ককায়েকৰ লগত মোৰ ভাল আছিলে কিন্তু ককায়েকে কেৰেলাত গুচি যোৱাৰ কাৰণে মই আছামীৰ ঘৰত জোৰ জবৰদস্তি সোমাই যাওঁ মই জব্দনামাত চহী থানাত কৰোঁ সত্য নহয় যে জব্দনামাবোৰ মোৰ সন্মুখত কৰা নহয় আজি মই আদালতলৈ what is written my lord I have not been able to read my lord লৈ অহা নাই সত্য নহয় যে মোৰ বিবাহ হোৱা নাই my lord this is the evidence of PW1 my lord there is no such my lord any cross examination my lord that is my lord in effect of demand of dowry and my lord mental harassment my lord because whatever she has stated my lord that are not been able to my lord break by the my lord defense counsel my lord Now, my lord, lordship, PW2, my lord, I am not reading, my lord, because she is the my lord mother. But mother has witnessed, my lord. Mother has witnessed the incident, my lord. That is why I am just reading the my lord 2 line, my lord. তাৰপিছত মই আৰু জোঁৱাইক বুজাই দিবলৈ যাওঁ তাৰপিছত আছামী আমাৰ ঘৰত পেট্ৰল ঢালি জুই জ্বলাব নাপালে আছামীৰ ঘৰত পেট্ৰল ঢালি দিয়ে আৰু মোৰ ছোৱালীক ঘৰৰ ভিতৰত থাকে লগে লগে মই পুলিচক খবৰ দিওঁ পুলিচ ঘটনাস্থলীলৈ আহি জুই নুনুমালে মোৰ ছোৱালী জীৱনটো অগ্নিদগ্ধ হ'ল হয় জ্বলা বস্তুবিলাক পুলিচে দোকানৰ ভিতৰৰ পৰা জব্দ কৰিছে আছামী ঘটনাস্থলীত পুৰা পুলিচে এৰেষ্ট কৰে মানে হি ৱাজ এৰেষ্টেড red-handed my lord while my lord he tried to my lord set her abuse my lord now my lord cross examination মোৰ ছোৱালীজনী পলাই যায় নিয়ম নীতি কৰা সামাজিকভাৱে বিবাহ নাইবা ৰেজিষ্ট্ৰেশ্যন হোৱা নাই দোকান জ্বলতে মই বাহিৰত আছিলোঁ my lord see this is our cross examination my lord দোকান জ্বলাতে মই বাহিৰত আছিলোঁ জুয়ে কেনেকৈ জ্বলে মই নাজানো 500 টকাৰ বস্তু নষ্ট হৈছে দোকানৰ সত্য নহয় যে কোনো মাৰপিটো টকা দাবী কৰা নাই, সত্য নহয় যে মোৰ ছোৱালী আছামীৰ লগত বিবাহ হোৱা নাই। Now, my lord, PW3, I am not reading, my lord. I'll take your lordship to PW4, my lord. আসামিক চিনি পাওঁ, ধন হাজৰিকা ওৰফে পুৰুষ ধুনু বুলি চিনি পাওঁ। ৰিণী হাজৰিকাক চিনি পাওঁ, উভয় পক্ষই স্বামী স্ত্ৰী হিচাপে থকা দেখা পাওঁ। ঘটনাৰ দিনা ৰাতি 8 মান বজাত মই কাজিয়া লগা দেখা পাওঁ। মই আসামিক কাজিয়া নকৰিবলৈ কওঁ আৰু বাধা দি আহোঁ। পিছত দেখা পাওঁ যে আসামীৰ দোকানত ঘৰ জ্বলি থকা দেখা পাওঁ আৰু ভিতৰত থকা ছোৱালীজনীয়ে চিঞৰি আছিল। পুলিচ গৈ দুৱাৰ খোলে আৰু ছোৱালীজনীক ওলাই আনে। This is very important matter because this witness is a matter independent witness matter. Neighbor. ছোৱালীজনীৰ পৰা আসামীয়ে টকা দাবী কৰে। আসামীজনৰ ঘটনাস্থলীত পুলিচে আটক কৰে। আমি পিছত ঘৰটো নুমাওঁ, লগত আসামীৰ দেউতাক ভায়েক উপস্থিত আছিল। উভয় পক্ষই বিবাহ পাতি আছিল ভালকৈ, কিন্তু পিছত কাজিয়া লাগে। Now my cross examination. বিবাহৰ তাৰিখ মনত নাই, সামাজিক ৰীতি নিয়ম ধৰি বিবাহ কৰা নাই। কিহৰ কাৰণে টকা বিচাৰি সেইটো নাজানো, বোধ হয় বেলেগ কাৰণে টকা বিচাৰিব পাৰে। In this respect, my lord, the defense just brought, my lord, that the accusers demanded money, my lord, through their cross examination. পেট্ৰল ছটিয়াই আসামীয়ে সত্য হয়নে দুৰ্ঘটনাৰ বাবে ঘটনাত পেট্ৰল ছটিওৱা হয়? মই পুলিচৰ আগত ষ্টেটমেণ্ট দিয়া নাই মানুহ। Only this part, my lord, cross examination was done, my lord. There is nothing has been, my lord, able to brought by the defense, my lord, during her cross examination. My lord, PW5 is the IO, my lord. I am not reading his statement, my lord, because he is only, my lord, investigated the matter, my lord. Now, lordship may kindly see, my lord, the 313 statement of the, my lord, accused person, my lord. There is no such explanation, my lord. He has simply denied, my lord, মিছা অভিযোগ. Only, my lord, in the last question, my lord, আপুনি কি ক'ব? মই নিৰ্দোষী, মোৰ ওপৰত মিছাকৈ গোচৰ দিছে, মোৰ ভাইৰ লগত সম্পৰ্ক আছিল, ভাই কেৰেলাত গুচি যোৱাৰ কাৰণে তাই আমাৰ ঘৰত আহি সোমাই, মই তাইক বিয়া পাতা নাই, কেৰাচিন ছটিওৱাৰ পৰা জুই জ্বলাই, কেৰাচিন চাকিৰ পৰা জুই জ্বলাই, my lord. But eyewitnesses, my lord, the PW4, my lord, has clearly implicated, my lord, that, my lord, the accused person tried to set her address by, my lord, pouring, my lord, petrol. আপুনি সাক্ষী দিব নেকি? মই সাক্ষী নিদিওঁ, my lord. Now, my lord, the trial court, my lord, convicted, my lord, says only, my lord, the appellate court, my lord, reduced the sentence to 6 months, my lord. Lordship may reduce, my lord, the judgment of the appellate court, my lord. That is paragraph 13, my lord. On close and careful scrutiny of the evidence on record of the prosecution, it appears from the evidence on record PW1-2 that PW2 was the mother, my lord. That the accused demanded cash amount of 20,000 to the complainant, PW1, and failure on her part to meet up the demand, the accused started physical torture upon her and drove her out from the matrimonial house. It also appears that no formal marriage was performed in between the accused and the complainant, PW1, but the fact of living together as husband and wife last 1 month by the complainant and the accused is not disputed by the accused. PW1 and 2 have also exaggerated in their evidence that the accused made an attempt to commit mischief by setting on fire the dwelling house of the mother of the complainant. However, it is not specifically denied by the defense about the subjecting mental. Well, this is important, my lord. However, it is not specifically denied by the defense about subjecting mental and physical cruelty upon the complainant by the accused with intent to extract some demand as dowry. The learned court below has rightly convicted the accused appellant under section 498 IPC. I found no ground to interfere with the findings of the learned court below. The appeal has got no merit. In result, the appeal is dismissed on contest with modification of sentence. The conviction and sentence of imprisonment for 3 years and to pay fine of rupees 10,000 in default. SI for under 6 months is hereby reduced to undergo SI for 6 months and to pay fine of rupees 2,000 in default aside for another 1 month. If realized, the entire fine money is to be paid to the complainant as compensation under section 357 CRPC. And send down the HR manner. And one of this appeal was dismissed by the accordingly, but modified the section. Now, my lord, the mere scrutiny and the evidence of materials on record, my lord. PW 1 and 4, my lord. PW 1 is the my lord victim, my lord, and PW 2, 4 is the independent witness, my lord. He has implicated, my lord. The accused, my lord, tried to set her ablaze, my lord, by boarding petrol, and my lord, there was demand of dowry, my lord, which my lord have denied, my lord, during the cross examination. So this is my humble submission, my lord.
FIR was registered under section 498A and 436. No, for a moment, I'm reading 436. FIR was,
436, ultimately 436 conviction was not there.
no, charges were all not framed.
That was.
Charges were also not even framed. Then there is no point of giving emphasis to the point that there was some kerosene was poured, something was put. As because there was no charges framed under 436. Only 498A, and to bring home the ingredients of 498A, the first ingredient is that the parties should be legally married, my lord. And it is observed in that the court has found from the findings that there was no formal marriage. And I have placed those judgments which says, my lord, that marriage is first foremost required for a conviction under 498A, but that is missing, my lord. If the ingredients are not there, my lord, conviction cannot be based on these evidences, my lord. The first thing is that 498A, whether it is applicable or not. If there is no marriage, it cannot be applied. My lord, that's what the Supreme Court says, and the judgment of our High Court, my lord. On that count, my lord, itself, the 498A cannot be sustained.
Okay, I could order it.
498A section itself starts, my lord, from husband. It is the husband who have to do it. And to be a husband, you have to be married, my lord. She was 14 years. Even if they had solemnized it socially, my lord, that would also have no ramification in this to the effect, my lord.
Submission of protection. Not Mr. P. Hajarikan.
PK Muni.
Oh, sorry, PK Muni. Have Mr. PK Muni, the counsel for the petitioner, and also have Mr. RJ Bova, the learned additional PP, appearing on behalf of state respondent. But he listen applications very so it is submitted by Mr. Muni that initially the case was registered under section 498A. Submission to get voted. Initially, the earlier part, the charge sheet was framed on 498A, na? And 436.
Charge sheet 436 and 498. Charges were framed 498.
I believe the case was registered. How would the factory? Okay, order is reserved for past year.
Whether 498A is affected.
Upgraded, item 33.
So we upgraded the matter as we have seen you sitting in the, from the morning itself. Now, what is the matter? In fact, you are
I am from the
Sorry, respondent.
Respondent.
Now the petitioner is not in there. When it was a matter was earlier part heard or what?
No, it was not part heard.
Was not part heard.
No.
Mr. Biswas is there, I think, na?
Yes, Lordship. In this matter, we want to seek for 1 more week accommodation, Lordship.
1 more week
Week.
accommodation. But you were enjoying the interim, I think.
Yes, yes, we are
Interim was
interim.
there.
Yes. Lordship, that interim may continue till the next date of it.
That will obviously it will be your submission on your side. You are representing respondent number 2.
Respondent number 2, yes. My lord.
You are MS.
AK Choppy, Lordship, appearing on behalf of Mr. and Mrs.
So also appearing on behalf of Mr. M. Biswas. And also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. And Mr. G.K. Gupta for the respondent number 2. So heard Mr. G.K. Gupta, the learned counsel for the respondent number 2. It is submitted by MS so and so that 1 week time is needed for their preparation and accordingly paid for an adjournment. Considering the prayer made by this so and so, list the matter accordingly after 2 weeks. Yes. This we are giving you 2 weeks. But,
Kindly fix a date.
pardon?
Kindly fix a date.
Date you want? First week of June. 5-6. List on 5-6.
If they apply to.
Obliged.
5-6 interview continue to link date of listing. Okay.
31 and 32.
My lord, 31, 32, my lord, kindly adjourn for the day, my lord. My senior, my lord, teacher, I agree, my lord, difficult.
Roy Chaudhary is there.
Yes, yes, ma'am. Yes, some difficulty. Adjourn for the day, my lord.
You are Mr.
K. Uddin, my lord.
K. Uddin.
Yes.
So you are for the respondent.
Yes, Lordship.
In item 31, for the respondent, Mr. Dinak name is there. And item 32, name of Mr. S.C. Biswas is there. You are appearing for
Item both
both
31
the
and
items.
32.
31 and 32.
Respondent number 1, we are for respondent number 1 in item number 31, Lordship. Null petition 973 of 2019.
Hmm.
And for a respondent number 2, we are for item number 2 in respondent in item number 32, we are for respondent number 2, Lordship.
In 32, you are for the respondent number 2.
Yes, Lordship.
And in 31, you are for the respondent number 1.
1.
So state here is the respondent number 3. And Mr. K. Uddin, appearing on behalf of Mr. P.K. Roy Chaudhary, paid for an adjournment. Stating that due to his personal inconvenience, will not appear before the so and so. Also heard. You are MS?
You, Nanda.
You?
Nanda.
You, Nanda, appearing for the 31 not 31, you are appearing for respondent number 2.
1, Lordship.
Sorry, 1. Aru state was a respondent number 2.
3.
Sorry, respondent number 3 and the item number 32. Same order, item number 32. She is appearing for respondent number 2. And state is for 1. Those matters will be listed after 2 weeks. Is there any interim, anyone? No.
Interim, not required.
You are not, you don't know, no?
Interim is there, my lord.
Interim is not there. No, I have
In the
stated from,
maintenance, there is.
Maintenance, there is interim, but it,
huh? Pardon?
Interim? It need not be extended, my lord. Already there, till disposal of the criminal petition, my lord.
Oh, already was there.
Yes.
Okay, okay. After 2 weeks, it will be.
Obliged.
This is
This
okay.
is.